December 2nd, 2022 to order. We have two new members I want to welcome. Judge Amy Guerrera, she's sitting over to my left, and Ashley Silva Guzman, who is over there on the right. And I think for their benefit, before we get started, why don't we go around the room and just introduce ourselves. And if you want to say a little bit about what you do, or in my case, what you used to do, go ahead and do that too, just so they get a sense of who we are. I'm, again, Paul Kramer, the chair. I'm a retired attorney for the state of California, most recently the California Energy Commission, and a former member of the Board of Governors of the bar when it was called that. Let's go around to the right, Amy. And remember, folks, you have to turn on your mic. You'll see a green ring around the bottom of the shaft when you do that.
Good morning. I'm Amy Nunez. I'm the Director of the Office of Admissions.
Good morning. My name is Michael Cow. I'm a cardiologist.
I'm James Bolton, retired professor from California State University, Los Angeles, and former member of California Medical Board.
I'm David Lane. I'm the attorney for moral character determinations at the State Bar.
Good morning. I'm Tara Clark. I'm the Program Manager for Moral Character.
Dolores Heisinger. I was staff with the California Teachers Association when I retired.
Larry Kaplan. I am an appointee of the Speaker of the Assembly, and I am a grant writing and fundraising consultant to charities and nonprofits.
My name is James Efting. I'm a trust and estates attorney.
Natalie Leonard, the Principal Program Analyst for Educational Standards.
I don't know if oh, there it is. Hi, I'm Ashley Silva Guzman. I am the new member, and I'm an employment attorney here in LA.
Good morning. I'm Tammy Campbell, and I'm the Program Manager of Operations in Admissions.
Morning. I'm Bethany Peak. I am an attorney member.
Good morning, Kareem Gongora. I am from the Inland Empire, and I'm a public member.
Good morning. I'm Alex Lawrence. I'm a public member working in higher education at UCLA.
Good morning, Ms. Guzman, Your Honor. My name is David A. Torres. I'm a member of the California Bar and criminal defense attorney out of the beautiful desert known as Bakersfield, California. And I've been a member of this committee for quite some time. I used to be a trustee back in 2012 through 2015, and I believe my last 2 years I served as a liaison and haven't gotten off.
Christina Dole, State Bar staff. I oversee the examination grading and the testing accommodations process.
Amy Guerra, I'm a judicial officer with the Fresno Superior Court. I've served on judicial committee, judicial council advisory committees, as well as California Judges Association committees. I'm really happy to be on this committee, and I look forward to participating. Thank you.
Good morning, Vince Reyes. I'm a public member. I'm from Northern California, San Francisco area, and I'm sort of semi-retired from doing administrative work for Alameda County around diversity and civil rights.
Devin McFarland, Senior Administrative Assistant in the Office of Admissions.
Alex Chan, attorney.
Audrey Chang, the Assistant Director of the Office of Admissions.
Okay, and then on the Zoom, we have a couple members of the committee. I guess I better call them out because you may be seeing a different order of people than I am. Let's start with Jean.
Good morning, Jean Krasilnikoff. I am with the State Bar's Office of General Counsel.
Judge Herman.
I'm retired from the Santa Barbara Superior Court, and like our chair, I was formerly a member of the Board of Governors when it was Board of Governors before it was Board of Trustees.
Tyler.
Good morning. I am an administrative assistant at the Office of Admissions.
Lisa?
Morning, everyone. My name is Lisa Cummins, and I oversee exam development.
Robbie?
Good morning, everyone. I'm Robbie Brody, an administrative law judge here in Pasadena, California, and an attorney member. Hello.
No bird. Caroline?
Good morning. My name is Caroline Holmes. I'm an assistant general counsel with the Office of General Counsel. Nice to see everyone.
And Donna?
Good morning. Donna Hershkowitz, I'm the Chief of Programs and the Legislative Director at the State Bar.
So with that, we have a somewhat longer housekeeping and public comment speech that I will start now. First, let's talk about closed captioning. We turned that on for our last meeting and found that in the room here, the closed captions basically covered the bottom third of the screen. So we found a solution to that for those who don't need closed captions. That is that you can turn them on if you desire to view them, but they don't have to cover the screen. And to do so, you would hover your mouse the lower part of your screen where the Zoom toolbar is located. And in that toolbar, there should be a section that's labeled CC for closed captions, I guess. Please select that option, which will pop up a menu, and then you would select Show Subtitles to start viewing the closed captions. And presumably, you could turn them off the same way. If you're still having technical difficulties, please don't hesitate to contact State Bar staff for further assistance. Now on to the instructions and soon our call for public comments. The Board of Trustees recently adopted a public comment policy that applies to all bar committees, including this one. Its policy statement says, the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. Those public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct public business on behalf of the people of California in a timely fashion. Written public comment may be submitted to the email address on the meeting agenda. We encourage you to submit written public comments at least 24 hours prior to the start of a meeting. Written comments received less than 24 hours prior to the start of a meeting will be distributed the following business day. In this case, I guess that would be Monday. If you bring written materials to a meeting for distribution, they will be collected by the meeting secretary and distributed after the meeting concludes. For oral public comments, persons were encouraged to sign up to speak in advance of the meeting and will be called in the order they signed up. Persons attending the meeting remotely will be called in the order that they appear in the attendee list, and I'll explain how to raise your hand to tell us that you want to do that in a moment. And those joining us in the room today wishing to make a public comment may sign up on a sign-in sheet that was available right outside the entrance to our meeting room. Speakers cannot cede their time to another speaker, and it is not guaranteed that all who wish to speak will be able to do so. To facilitate hearing from as many members as possible, we encourage you not to repeat points that were made by previous speakers. Simply say that you agree with them. To allow the committee the time needed to deliberate on the important topics that it will be discussing today, we will be limiting public comments to 3 minutes per person. Law school deans or a designated school representative may speak at the time their items are heard by the committee later on our agenda. They would be allowed to speak right after the staff presentation for up to 5 minutes. Others who wish to speak in support of a school must make their comments during this public comment window that we are about to open. I've also been asked to remind us all of the State Bar's anti-discrimination and anti-harassment policy, which says the State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must, at all times, treat all other employees, job applicants, and persons providing services to the State Bar with respect and dignity in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business, service, or professional relationship. We're almost there. If you are on Zoom and want to speak, you'll need to raise your hand unless you are already on the pre-meeting sign-up list. To do so, you click on the hand icon that's at the bottom center of your Zoom window. If you're participating by telephone, you may virtually raise your hand by pressing *9. That's the star key and then the number 9. Our coordinator will call members of the public, starting with the pre-meeting signups, then the Zoom list interspersed with in-person signups in the order that they raised their hands or signed up. Staff will enable the microphones of the speaker and start the timer and call out when 30 seconds remain. I presume we have some people that wish to make comments, so let's go ahead. Ms. McFarland, if you want to. Oh, I'm sorry, we forgot roll call. So let's do that, and then we will open the public comment.
Dr. Bolton?
Here.
Brody?
Here.
Dr. Cow?
Here.
Alex Chan?
Here.
Jim Efting?
Here.
Kareem Gangora?
Here.
Judge Guerrera?
Here.
Dolores Heisinger?
Here.
Judge Herman?
Here.
Larry Kaplan?
Here.
Alex Lawrence?
Here.
Esther Lynn? Bethany Peak? Ashley Silva Guzman? Vince Reyes?
Here.
David Torres?
Here.
Dr. Wilcoxon? And Paul Kramer.
Here.
Thank you.
Okay, so let's then begin with public comment. If you could call the first speaker.
Our first public comment will be from Benjamin Cohn.
Hi, thank you. Good morning. I'm calling or commenting because I think there's still been some points of confusion based on what I heard at the admission hearing yesterday as to the nature of criticism on the testing accommodation rules revision proposal and back-end policy proposal that was supposed to be circulated for public comment. I actually haven't seen the public comment circulation where we would submit written public comment for the 60-day period yet, but it is not that it doesn't go far enough per se for the whole of it. The policy that was not changing the admission rules can be described that way. That policy deals with the evidentiary standards to get certain requests that have been approved by previous testing entities, such as 50% extra time and a semi-private room matched by the State Bar through a more streamlined process. So that is being criticized for not going far enough because it excludes most accommodations for physical disabilities, sets an exceptional needs standard for greater amounts of extra time that is unlawful, and has redundant requirements like a 5-year admissibility time limit for the prior approvals or evidence on those particular accommodations, the 50% extra time and semi-private room that should not be there when it's a permanent disability with same functional limitation. The criticism for the rules revision that's being still voted on is not that it doesn't go far enough, it's that it's actually detrimental. The admission rules need to be reformed desperately because they are facially discriminatory, but these revisions make it even more so, not less, and should be rejected and replaced. I've submitted a lot of written comment with exactly what it should be replaced by, which you're aware of. I encourage members of the public to use the written comment circulation period to clarify these points and focus especially on the processing time and the
30 seconds remaining.
collaboration of it. And lastly, I think that it doesn't protect the public to make constitutional challenges to the ADA, which the Ninth Circuit just held for purposes of requesting a brief from the DOJ that the State Bar is doing. Thank you.
Our next public comment is from Todd Hill.
Thank you very much. I appreciate the opportunity to speak. If any of you are not aware of my circumstance, then I will assert that one of your peers, whether they be a fellow committee member or a staff member, has failed in their duty of absolute candor to the tribunal, their fiduciary responsibilities, their duty of loyalty to you, the duty to inform. And I encourage you to, as we talk about plausible denial and the lack of it here, consider that. Rhetoric versus conduct. The majority of professional responsibility arguments are conduct-based. The first mandate is protection of the public. That's the State Bar Act's first mandate. And most importantly, protection of the public regardless of conflict of interest. That would be both personal. Hey, I want to keep making this nice paycheck, but I don't want to report this bad stuff. Or organizational, institutional. You know, we have this policy and it violates 2 state laws and federal statute and is allowing school to shortchange its students by giving them 2 units instead of 3, prohibiting them from transferring. So the vertical market monopoly regulator, who's also defined students mysteriously in its quasi-legislative rulemaking as not members of the public in defiance of both the state and federal constitution. For no grant of power has been given to establish who and who is not a member of the public other than those sworn to the standards of the State Bar Act and who are the true members of the bar. So here, if your goal was to frustrate the lawful grant of my degree, you've taken away my ability to graduate expressly through your own acts. You've allowed my institution to extort from me, to break and defy your own rules and guidelines for over 1,200 days.
30 seconds remaining.
Oh, I'm sorry. Was I screaming?
30 seconds remaining.
Oh, see, that interrupts me and takes time. It's also a form of suppression. There's a war you guys have on this because this is the most effective way the plausible denial is eliminated. That's why you don't want anybody to talk very long. That's the truth of it. And it's in the record. Thank you.
That concludes our virtual public comment. I believe we have one member of the public that would like to speak, the Dean of People's College.
Dean, do you understand that you'll be given 5 minutes to speak when we hear the item? Would you prefer to do that? Okay. So she's saying she's going to wait until the item comes up. Thank you. That's it?
That is it.
Okay, that ends public comment. Thank you to those who made both the oral comments today and the written comments that we received this week. I'll note that we have 3 items on our agenda for which we have set specific times. And those are our planning session, which will start no earlier than 10 a.m. today. We have a hearing for American Heritage School of Law. That's scheduled to start at 9 a.m. tomorrow. And then we will be discussing and approving written questions for inclusion on the February 2023 California bar exam tomorrow afternoon, beginning at 1 p.m. That's going to be in closed session, though, so I wouldn't advise anybody to come here to watch that unless you find our hallways particularly attractive and pleasant place to hang out. So the next item on the agenda is approval of the October 14, 2022 Committee of Bar Examiners public meeting minutes. That's attachment O100. And I'll note as we start to vote on this item and others that one of the things that we're going to hear about later is that we have changed, the Board of Trustees has changed the rules of order that apply to themselves and committees such as ours, replacing Robert's Rules of Order with Rosenberg's Rules of Order. And one of the key changes there is that unlike the old rules, the chair is allowed to vote. So I will start voting on all the motions now unless I choose to abstain. Sorry? We're going to have a presentation on that later. So I can ask the simple answer, I think, as the question is, why did they do that? I think these rules are considered to be more user-friendly and easier for us to apply. And of course, we will see as we start to use them. So do we have any corrections or amendments to the minutes?
I move to approve the minutes.
I'll second. This is Kareem.
Okay, take the roll.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora?
Yes.
Judge Guerrera?
I wasn't present, so I would abstain for that one.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Bethany Peak?
Yes.
Ashley Silva Guzman?
Abstain.
Vince Reyes?
Yes.
David Torres?
Here. Yes.
Dr. Wilcoxon? And Paul Kramer.
Yes.
The motion passes.
Thank you. So it's too early for the planning session, so we will move on to the next item, which is the director's report.
Good morning, everyone. The director's report will start with the Provisional Licensure Program update, and that will be presented by Donna Hershkowitz.
Morning, everybody. I apologize that I could not make it there in person. I tested positive for COVID yesterday, so I am appearing from home today. I just wanted to provide an update for you all on the action that the Board of Trustees took at their November 17th meeting regarding the Provisional Licensure Program. Just a little background for those in the audience, as well as our two new members of the committee. As most of you know, the State Bar adopted the Supreme Court adopted two rules of court creating two separate provisional licensure programs. The original provisional licensure program was open to 2020 law graduates. And subsequently, we adopted the Pathway program, which was open to those individuals who had previously sat for a bar exam, scored between 1390 and 1439. And this is on a bar exam that was taken within the period of July 2015 to February 2020. Those pathway programs, the original in particular, was developed as a response to the pandemic and the situation that 2020 law graduates found themselves in as they graduated from law school. The uncertainty of when the bar exam was going to be scheduled, then the transition to a remote bar exam, the first time that we were giving it remotely, with the delayed start date, the economic conditions that the country found itself in, and many law students as well, and the conditions that just made it such that sitting to study for and take a bar exam may not have been possible, and the need to begin getting an income as quickly as possible may have been more severe than in normal situations. And so we created that provisional licensure program for 2020 law graduates. That program it essentially allowed these 2020 law graduates to practice essentially as a lawyer, but under supervision of a lawyer who met our eligibility requirements. And by the end of the program, they needed to pass the bar exam in order to be admitted and to be able to continue to practice law in any form or fashion. Subsequent to the launch of that program, or the adoption of that program, we had created the Pathway program for those who had taken a bar exam and received that 1390 to 1439 on that bar exam. That was done also in response to the pandemic, as well as in recognition of the fact that for the October 2020 exam and going forward, the Supreme Court had lowered the passing score from 1440 to 1390. And so recognizing that those who had scored that 1390 in the past 5 years would be permitted to participate in this provisional licensure program. For that cohort, and we'll call those the Pathway provisional licensed lawyers, for that cohort, they did not need to sit for a future bar exam. They needed to complete 300 hours of supervised legal practice and receive an evaluation from their supervisor indicating that in the supervisor's judgment that they possess the minimum competence of an entry-level lawyer. And then those individuals would be admitted to the bar. Obviously, all other requirements for admission needed to be met, positive moral character determination. We also required for both the original program and the Pathway program that they complete the 10-hour new attorney training, which is required of attorneys who are licensed within their first 12 months of licensure. We required them to complete that during the provisional licensure program. And obviously they would need, as you always would need for entry to the bar, they would need to pass the multi-state professional responsibility exam, or the MPRE. So both of these programs were launched and were successful. We had 1,585 participants between the two programs. They were both originally scheduled to sunset on June 1st of 2020. That June 1st date was extended to 2022, I'm sorry. That June 1st date was extended through December 31 of 2022. So here we are, we found ourselves as we were coming up to December 31, needing to provide a recommendation to the Supreme Court about what to do with regard to the participants who were remaining in the program. Tyler, could you put the slide down? If it just has my name on it, I'd rather just have everyone see each other. So we surveyed the participants in the program, current and former participants in both the original program and the Pathway provisional licensure program. We surveyed the supervisors from each of those programs. And then we also surveyed those who were eligible to participate in the Pathway program based on their bar exam score over the prior 5-year period, but who did not apply to the program. And we asked them different questions. We asked them why they didn't apply. The others, we were asking about the program itself and how it was operating. So looking at the results from that survey, considering the State Bar's mission and a variety of policy objectives, which are laid out in the agenda item that was presented to the Board of Trustees, and the PowerPoint, which I believe is attached to the CBE's agenda materials, we came up with 5 options to present to the Supreme Court. Before we had formulated the options, I had surveyed the members of the Committee of Bar Examiners to ask for their input. The survey generally talked about the the kinds of things that were reflected in the options, but were not sort of the 5 specific options because we had not developed them at that point. So we also shared with the board and is shared in the agenda item the views of the members of the Committee of Bar Examiners who had individually responded to me at that survey. Obviously, it would have been better had we had time to really discuss that in a committee meeting where you could have developed your opinions based on the discussion that you were having. So I understand it's difficult to answer survey questions in isolation without that discussion. But as a result of all of that information, the board adopted the 5 options that were spelled out in the agenda item and recommended those to the Supreme Court. And those 5 options are as follows. The first option is the only one that relates to the pathway program. And that option is to extend that pathway program for 1 year for a set, and I will tell you in a minute what that set is, for a subset of those who are currently active in the program, and also to reopen the program with a 6-month application period, reopen the program through December 31, 2025, for those people who were eligible but did not apply. The subset that the program would be extended for applies for all of the options, and it's based on the fact that we needed to consider our public protection mission, and so the only people that this option to stay in the program for an additional year applies to are those who hadn't yet completed the hours and or hadn't yet received the evaluation from their supervisor. In other words, you cannot still have an outstanding, at this point, you have to have a positive moral character determination in order to continue on in the program. At this point, you needed to have passed the MPRE in order to continue in the program. And at this point, you needed to have completed the 10-hour new attorney training in order to continue in the program. Those limitations apply for all of the remaining options. So then the next 4 options that were approved by the board and submitted to the Supreme Court deal with the original provisional licensure program. And we would expect the court to select from these 4 options. One of those 4 is just to extend the program through December 31, 2025 to allow additional opportunities to sit for and pass the bar exam. Another option is to extend the program, and all of the options have that December 31, 2025 date. Extend the program and still require the participants to take the bar exam, but if they have satisfied a certain number of hours to be defined by the Supreme Court, if they select this option, a certain number of hours of supervised legal practice, then they would be eligible to sit for the attorney's exam as opposed to sitting for the 2-day bar exam. The last 2 options, extending the program for those who meet the criteria, right, have a positive moral character determination, have completed the 10-hour new attorney training, have passed the MPRE. The only thing that's remaining is they haven't passed the bar exam. Extend the program for them, and we're talking about 125 people or so. While during that extension, over the course of the next 12 months, the State Bar would develop for the Supreme Court's consideration a supervised pathway pilot project that would allow this cohort, this 125 or so cohort, to become licensed through a supervised pathway without having to sit for another bar exam. And then the final option, again, for the same cohort of 125 people in the original program, extending it through December 31, 2025, but instead of creating a supervised pathway pilot project, the State Bar would come up with an alternative licensure scheme, which could take the nature of you basically are a provisionally licensed lawyer as a permanent status, where you would always have to operate under supervision, or it could be a different a status where you wouldn't operate under supervision, but you would have limited scope authority, or something else, but some kind of alternative licensure scheme. So those were the five options that were submitted to the court. We know the court is going to do everything in its power to make a decision before the December 31 expiration of the program, and then depending on what options are selected by the court, we may be bringing the next steps back to this committee. If, for example, the court opts for the option that we should extend the original program and develop a supervised practice pathway, then that's something that pathway is something we'd be working with this committee on. So those are the options that were submitted, and we did just yesterday formally transmit those options to the Supreme Court, and we expect to hear back from them as soon as they are able. Happy to answer any questions.
David?
With regard to option 4, that's extend the PLP, permanent alternative licensure status. If I recall, that one was a result of the Supreme Court reducing it, and I may be wrong, but 1440 to 390. Then these individuals, what they would do is go in and work with a law firm, earn several hundred hours, and of course there were other obligations that they had to overcome in that. I believe that last time we discussed it, that particular program was quite successful. Am I correct?
So I'm sorry, David. I think you may be conflating a couple of things.
Okay.
So we have the pathway program for those who scored between 1390 and 1439 on a bar exam. There were 673 people who participated in that program. 500, and I'm sorry, I don't have the statistics in front of me, I think it was 538 or so, met the hours requirements, met all of the other requirements, and were admitted to the bar through that program. An additional 24 took what I expect, I didn't look back at the data, but took the, I think the February 2021 bar exam, right about when the program started. And so we're admitted after having passed the bar. But in that sense, that we think that program was very successful. But that's not, so what the only option that applies to that program, those who got between 1390 and 1439, is to extend it for the 29 people who are remaining in the program who have yet to complete the hours or have the evaluation, and to reopen it for the potential 1,154 people who qualify based on their bar exam score, but had not yet hadn't applied for the program. And what we discovered is that the vast majority of the people who responded to our survey, the reason they didn't apply for the program was because they had not heard about it. Due to a miscommunication on the state bar's side, we had intended to email all people who had the eligible bar exam score, who scored in that range. We had intended to email all of them and make sure they were aware of the program, and that didn't happen. And so, to the extent that the last time you took a bar exam was 2015 or 2016, you've moved on in your life to other things. You moved to another state. You're not checking the State Bar's website or the State Bar's social media feed, so you wouldn't have come across the program. So there are quite a number who weren't aware of it, and so the second part of that option was to reopen the program for those 1,154 people if they choose to apply.
And my apologies, you're right, it's the 1390 to 1439. And I was quite impressed with it. I was quite impressed with the numbers and the diversity of individuals who participated in that program. You know, several years ago, former Supreme Court Justice Cruz Reynoso came and spoke to the Board of Trustees at an event, and you know, often one of his pet peeves was the state bar, because what happened was not the state bar, but the exam itself. And it was because he was familiar with a lot of students that he worked with and who had challenges with the bar exam itself, but yet he worked with these individuals. They worked for him at UC Davis, and he always felt that they were very capable attorneys. And I happened to meet one of these individuals. She passed the bar, and she's doing very well in the city of which she lives. Later on, with the program that we've got going, I made it, I basically wanted to find out which individuals were involved in this particular program, and just at least have an opportunity to watch where they go with this. And I spoke to their supervisors. These are primarily at the state public defender's office. Just about everyone that participated in the program are now in a preliminary hearing court or misdemeanor courts, and some of them are now in felony courts, and they are excellent lawyers. And I think that oftentimes when people think about California and what our bar pass rates are, they look at it somewhat draconian. Some of us do, some of us don't. But either way, I think this program, and this is just my piece here, I think a program like this should be at least considered as an option, but on an ongoing basis, because what it's actually doing is it is increasing the percentage of lawyers in the state of California, but it's addressing the needs of the 4% total number of Black lawyers, the 6% or 7% total number of Latino lawyers. And we have other Asian, I've seen several Punjabi attorneys that are participating in the program and have gone through and gone on to be successful lawyers. And I think that having a program like this does serve the community, and it does serve the public protection when we think about the obstacles that these individuals have to go through. And my position here would be that something like this go on and not terminate, and perhaps make this a working part of the state bar. Thank you.
So thank you, David, because that jogged my memory on something that I should have mentioned. So what you're really talking about is option 3, which is the supervised practice pathway. The Board of Trustees, several members of the Board of Trustees expressed similar views, David, to what you said, and additionally noted, one of our members noted that that he was struck by the fact that 15% of the survey respondents were participated did their provisional licensure program in the nonprofit world. And about less than 1% of attorneys work in legal aid. And if you've got 15% working in legal aid in this, that was also something that was very uplifting. And so the board, we had some discussions about, there are just, there are obviously discussions going on nationwide about the best ways or different ways to equally determine minimum competence, and a traditional bar exam not being the only way to determine minimum competence. One of our board members said, for some, the bar exam is a test of how well you take a test, and it's not the only way to determine whether somebody is minimally competent. And that's what having this supervised pathway would allow us to do. Option 3, using this cohort of 125 or so people, would allow us to explore those ways. So the board actually asked that when we transmitted the options to the Supreme Court, that we indicate the board's strong particular support for that very option.
Any other questions? Larry?
Any prognostication as to what you think the court will do?
I would never do that in private, much less in public. the court will consider all of the information before it and make the decision that it thinks is best.
Don, if I may, Mr. Chair. In line with what Mr. Kaplan said, would this option be something that the Blue Ribbon panel can actually consider and study as well? Look at the benefits that our state has derived from this program that we implemented?
And that kind of tacks on to one of my questions. How does this pathway differ from what the BRC, Donna, has been unable to come to a consensus about?
Well, so that is something that we teed up in the agenda item, that there are absolutely some who would say you can't go there, right? This option of a supervised practice pathway is in the purview of the Blue Ribbon Commission, and they have been unable to come up with a recommendation on this one way or the other, to proceed or not to proceed with a supervised practice pathway as an alternative way to determine minimum competence. Our view was that, staff's view was that the Blue Ribbon Commission was looking at a permanent, ongoing process for allowing thousands of people potentially to be admitted pursuant to this pathway, and that's daunting. And so what we felt was that this was this proposal, this option was a way to provide information to the Blue Ribbon Commission, or a successor to the Blue Ribbon Commission, to, after we get the data on how this works with a 125 or so person pilot project, to consider what a permanent program should look like, or if we should have one at all. But this would really enable us to provide the data and the sort of real life California-based statistics and examples on how this would work. And so, we saw it as complementary to what the Blue Ribbon Commission or a successor commission could choose to do in this arena. Obviously, not all members of the Blue Ribbon Commission agreed with that perspective, and there was some opposition to this alternative expressed by those who did feel that, no, this is something that's really within the purview of the Blue Ribbon Commission. That's obviously something that the court would need to consider.
So in effect, it's a pilot program.
Yes.
Now, would it affect the value of the results that the cohort that would be going through this is a subset of a year's graduating class, in that most of that class or some large percentage of that class has passed a bar exam and wouldn't be, and so you would be dealing just with those, in effect, those who are not as good at taking exams, and would that make the results less informative?
I read, not a statistician, obviously can't totally speak to that, but it may very well be that if this were a permanent pathway to licensure, an option as a pathway to licensure, that would be the exact cohort that would go through this supervised practice program. I couldn't tell you. Maybe it is, maybe it isn't, because I don't think California would, certainly I don't think we are now looking at a supervised practice pathway as the only way to licensure. I think there would always be an exam option. And so I couldn't say who would be, part of that pathway or not, but it may be those who consider themselves not great test takers, would be ones who might walk into that, happily walk into that pathway as a way to demonstrate their minimum competence. There are some who say that is a much better way to demonstrate minimum competence, because they are practicing in real settings, having to do real work. We hope that a future bar exam will be structured in a way that is also more representative of what what practicing law as an entry-level lawyer would look like, and would be a good test of that as well.
Okay, that's the very complicated device to design and construct and test. My theory is that the court is going to decide something and give us very little time to implement it. And what assurances do we have that we will actually be able to participate in that as a full group, as opposed to a survey that was presented to us before we saw the details of what was presented to the board?
Yeah, all I can do is say what I've said before, which is if the court directs that we develop a supervised practice pathway, which our option that was presented to the court had us presenting that to them by the end of 2023, so giving us a year to do that. If that is the option that we select, we've discussed this at the leadership level, and the expectation would be that we would work with the Committee of Bar Examiners in coming up with that pathway. And by work with them, I mean have, in all likelihood, have a small group of people that we would do sort of hands-on, roll up the sleeves work, and then bring to the committee a couple of times for the committee's input as we are developing it. But it would be the work product of the Committee of Bar Examiners that would be recommended to the Board of Trustees and then ultimately the Supreme Court.
Okay, thanks. I'll note that we will be discussing with our representatives on the bar, the BRC, I keep forgetting what that expands to, later today, to give them some instructions as they go through the kind of final process that the BRC is going through. So David, did you have something else?
Just briefly, I mean, as Paul just mentioned with respect to allowing the Committee of Bar Examiners to at least have a voice into this, into adopting something like option number 3. For years, as long as I've been a part of the bar, not as a practicing lawyer, but with the Board of Trustees, and I know perhaps even going back to when Paul, a long time ago, was on the Board of Governors back then, the word access to justice has always surfaced. It's always surfacing because we've done a lot of things, or we've attempted to do many things in the past, such as the incubator program. We've looked at different ways, but the way that we've approached it is where we already have the lawyers on the ground. And I don't think that that's been quite successful, but I think that in looking at what we've done, and I'll tell you, Donna, last time we met and we discussed these percentages, I was very pleased and excited about it because I saw some hope. The fact that a lot of these individuals that did go to work went and worked for legal services, or in my place, GBLA, public defender's offices, and of course some went to district attorney's offices or county council. And a lot of these individuals were in fact providing assistance to individuals who normally don't get it all the time. And again, knowing that we were getting our poverty law firms filled with interns, it made me feel really good knowing that this is a program that actually works. So you really can't separate access to justice from this, because that, I think, is something that we have always attempted to achieve as a state bar board and as a Committee of Bar Examiners. Thank you.
Okay, anything else? Dolores?
2 questions. One is just a clarifying question. Of the options, 1, 2, 3, 4, 5, option 4 is the only one that potentially would certify lawyers without taking a bar exam. Is that correct? Potentially.
Options 3 and 4.
3 and 4? Okay. Second question. In the past couple of days, we received a public comment letter from an attorney who indicated in his letter, I thought what I read was that the Blue Ribbon Commission had decided against a non-bar passage pathway. Was he mistaken?
So the Blue Ribbon Commission was unable to pass a motion either supporting going forward or declining to go forward. So it's essentially at this point there was no motion adopted either way about a supervised practice pathway. We are just in the process of putting together the preliminary report of the commission that would go out for public comment, and then the commission can make its final decisions and recommendations based on the public comment that's received. But they considered over several meetings whether to adopt a supervised practice type of pathway, and did not have the votes to support it.
And we'll get into that a little bit more later when we have the BRC report. Okay, anything, Kareem?
Yes, thank you, Chair, and thank you, Donna, for your presentation. I've been watching this very closely, and so a lot of the updates and even the conversation today has been, in my opinion, very promising, and I do support my fellow colleagues Torres's position. When I evaluated the numbers, I think we had a nearly 80% success rate in the PLL program, and so what that shows me and what that tells me is that programs like that work. I know that we're kind of in a position where we're developing new policy and there has to be innovation in it. And you're seeing this occur statewide. You're seeing it with teacher credentialing all the way down to what we're doing with this program. And so I think it's an adaptation, I guess, to the culture and to the environment we live in. And also in looking at how we increase equity and access to justice in our communities. In my area, the Inland Empire, we're underserved. We don't have enough judges. We don't have enough lawyers. And so you see access to justice issues throughout the community. And so when I come here, someone that's a first-generation American, I really value that they do have these ladders to success and opportunity in this space, because I think that's what gets us to a place where we're able to serve the public and understand the public in the way that they want to be served. And so a lot of the issues that I hear on the front lines is people have distrust in the government, distrust in our practices, distrust in the things that we do. And so I believe fundamentally what we're doing here, and even just this open discussion, is creating the space to have these hard conversations about how do we move forward and get to a place to we have equity in our communities. And so I know it's not going to be solved overnight. I don't expect for everything to be perfect, but I do appreciate that the State Bar and even the committee members here today and the Board of Trustees and Supreme Court are even considering something beyond what we've been doing, because we've seen that when we bring people into spaces that they normally don't occupy, we see innovation and we see success. And so I guess, Donna, my comments are thank you. I know this isn't easy work. I know that even trying to measure and gauge the way it's going to go, I mean, I'm not a betting man, but it'd be impossible to hedge your bets. But I just want to make sure I'm on record saying thank you, and I appreciate the work, and also want to compliment my colleague Torres's comments.
Okay, anything else? Judge Herman and Robbie, are you comfortable with raising your hand when you want to speak using Zoom? Good. Okay, so we'll just look at your screen to see if you wanted to speak. Thank you.
You're welcome.
That concludes this item. And we are now on time for the planning session, but let's take a 5-minute break. And while we set that up, I see that Mr. Duran is here. I don't see Ms. Wilson yet. So we'll come back in 5 minutes and start the planning session. after it's over about whether this is a more appropriate move. The motivation for that was, January is practically halfway through our year, and talking about planning at the beginning or near the beginning seems more appropriate than near the middle. Although to say that our year ends and everything's over is not correct, because most of us are here for 4-year terms at least, and we just kind of roll over. But nonetheless, the idea is let's talk about planning sooner rather than later in the year. I'd like to invite Ruben Duran, who is actually in his second year now as chair of the Board of Trustees. Congratulations on that, I think. And
Thank you.
You wanted to speak to us a little bit, and we really appreciate you coming. I did wonder how long you can stay with us, though, because we do have some questions that are implied, especially in the outline that Vice Chair Dr. Cow and I prepared about our role. And as we said in that memo, we're trying to break down our understanding and rebuild it from the ground up. It's a discussion I don't know if we've ever had at the Committee of Bar Examiners, but we certainly have not had it in the recent past. And I, for one, and I'm sure others, really want to understand the broader context in which we exist, and perhaps discuss that among ourselves and with you. So with that, go ahead.
Thank you, Chair Kramer. Good morning, and I'm here for as long as you need me today. My calendar is clear, and I've been looking forward to the opportunity to sit and listen and participate in your discussions. Let me just start by saying good morning and thank you for the opportunity to join you. Thank you all for the hard work that I know that you do and have done as members of the Committee of Bar Examiners over the years. I would imagine that sometimes the work is unsung and sometimes even criticized. And I just want to thank you for your diligence and your efforts on behalf of the state, quite frankly, in our profession. I'd like to just start by introducing myself a little bit. I am the Speaker's attorney appointment to the Board of Trustees. I was appointed by the Speaker in 2018 and have served, as Chair Kramer mentioned, as the chair of the board last year, and this is just the beginning of my second year as chair. I think all of you know and understand that it has been quite a past few years for the State Bar as an organization. I suspect that you could all say the same for the work of your committee. By way of background, I am a municipal law practitioner and manage the Ontario office of Best and Krieger, which is a firm here in California servicing cities and special districts and water districts. I am the city attorney for the cities of Fontana and Ontario in the Inland Empire, and sort of public affairs and public policy is in my blood. It's part of my practice. It's sort of what drives me. And so the State Bar has been a wonderful place for me to spend some time and provide the state some service. I referenced the sort of the eventfulness of the past several years, not the least of which, of course, is the state and the world coming out of a pandemic. And for the State Bar, of course, we've got the recent revelations of Tom Girardi and what his practice did and how it affected the public protection issue in a very, very real way, bringing to light issues and problems that the State Bar has to confront and address. And so I certainly appreciate the fine work of Ms. Wilson and her staff in that regard, and my colleagues on the Board of Trustees. We recognize that the protection of the public is something that you all take to heart in your very unique role in the admissions process and administering the bar exam. We all know that the California Bar is widely acknowledged and sometimes even decried as the most difficult bar in the country. And so the work that you all generally do is important and of public interest. And I know that with what has gone on recently with the cut score issues, with the Supreme Court's appointment of the Blue Ribbon Commission, with issues such as the provisional licensure program and accessibility issues and challenges to the bar with respect to the exam, all of those things are not easily dealt with, right? They are all challenging issues. And so I appreciate the vigor with which you and your committee and the State Bar admissions staff address and try to tackle those issues, all in service to the public, right? And I think that is something that isn't said often enough, which is you guys are all volunteers and you are working for the betterment of the profession and for the well-being of the state. And so my heartfelt thanks to you for the work that you continue to do. I'm here just to listen and participate and to say thank you. So I'll stop there, Mr. Kramer.
Okay, thank you. And I'm glad to hear you can stick around. We look forward to your thoughts probably in a little bit. The plan was to get the right outline. We were going to let Ms. Wilson finish presentation she started at our October meeting on the strategic plan. How do you want to work that, Ms. Wilson? Do you want to just continue on, or would it be better to just start over? And you were time limited then, so you truncated your presentation, but I'll leave that decision to you.
Yeah, I think I did actually make it through the deck, but what we didn't have an opportunity to do is to get into the discussion, and you had posed some questions ahead of time. I think some of them are teed up in the memo that was posted for today's agenda as well. And so I know, one of the central sort of recurring questions you've had is about the role of CBE. And so I certainly have come prepared today to put forward potentially my own asks in terms of what you all might consider as you move into conversations about your 2023 work plan. So I wasn't thinking that I would go back through slides, but rather engage in a conversation. Happy to pull up the deck if you want me to do that, but I do think I went through the material.
Okay. One question we can just start with was you began to mention on the category of outreach last time. You talked about us reaching out to other organizations, recognizing that we already have relationships with the law schools, and we reach out to law students to provide them the help that we can give them. I'm wondering what other entities, organizations did you have in mind? And then you also mentioned something about adding additional members public members to various bar committees. I think that might have even included the Board of Trustees, but I think you had this committee in mind. And several people came up to me after your talk the last time and said, did you hear that? And I guess I was busy because I had to go back and listen to the recording, but I did hear that, and I think myself and others want to know more about what that entails and the rationale for it.
Okay, so I'll start with the first question. And this really goes to my statement about having an ask of the CBE. When I look back and reflect on the changes that were made as part of the famous or infamous Appendix I process, one of the shortcomings that was identified at that time that unfortunately I think still exists for us as an organization is our lack of kind of a policy home for understanding licensing trends with respect to the work of the CBE. We have kind of this hole generally in our organization. And by that I mean, we don't have our sort of finger on the pulse of what is happening in the other 50 states in terms of admissions and licensing, or Commonwealth countries, and increasingly, certainly what's happening in Canada has been of discussion here in the United States. We don't have any kind of built-in infrastructure for keeping track of all of that, for identifying trends, best practices, things that we might want to consider in California. So when I think about other relationships that it would be valuable for CBE to help us figure out how to foster and maintain, it's one with other bar licensing entities. Then if we step out more broadly, professional licensing, there are things for us to learn. Increasingly, we started to look at medical licensing. Why? Because it's obviously much more experiential than our process. And it contains the residency requirement, which is parallel in some ways to the kinds of conversations that are going around vis-a-vis supervised practice. So that's another set of relationships and in areas of exploration for the Committee of Bar Examiners. I know we've been so fortunate to have medical doctors on the Committee of Bar Examiners, but of course that's not a structural approach to facilitating the kind of subject matter expertise that ultimately we need to build into the committee. So those are a couple of relationships that I can think of. Others have to do with community-based organizations. To the extent that these organizations are serving members of the public that have legal needs, unmet legal needs, I think it would be valuable for the committee to have an understanding of what the unmet legal needs are, because ultimately our licensing infrastructure should be tailored or designed, at least in part, to increase access to representation for those who go without representation. And so I think this is another area for the committee to potentially explore. So those are just some. I could rattle off a whole host of partnerships potentially, but those are some that come to mind. On the second question, and I'm sorry that I forgot what it was. Oh, public membership. What I was trying to point out there is that for some of our committees and sub-entities, and I really do not know if this is the case for CBE, so I certainly was not meaning to call out CBE. We have an allowable number of public members, but it's not a mandatory requirement, or it's not a mandatory membership number. In years past, we have come under our allowable number. A great example of this is COPRAC, our Rules Committee, the Jenny Commission. We have not always had the number of public members that is allowable. I think what I'm seeing from our board, and this is really a message I'm getting from the board, and certainly the appointments liaisons to the board, is in the first instance, we need to maximize the number of public members on our sub-entities as allowable under rules, statutes, or whatever the overarching membership construction authority is. So that's the first thing, not sort of an overarching change of composition. For many of our committees, we don't have the authority on our own to change the membership composition. For some, we can, not for CBE. So I don't think, I wasn't intending to suggest that you should expect a change in your composition anytime soon. And again, I'm not sure where we are in terms of the number of public members on CBE in relation to the number of allowable or required public members.
Well, I think we have all the slots filled that the statute requires. I think it's a ratio, if I remember, of 10 to 9 or something like that. 10 attorneys, 9 public members.
I believe we have one vacancy in the public members.
Okay, we may have one public member vacancy, but that's really for the appointing authorities to work on. So maybe we need to just reach out to those offices and remind them, and we can certainly do that. Okay, thank you. That's very helpful. Mr. Duran, do you have any thoughts about that?
Just very briefly, I will echo Ms. Wilson's comments about the board very much wanting to ensure active public participation in across the agency, starting with the board itself, as a matter of fact. We've got very active public members, and if I'm not mistaken, the ratio of public members to lawyers sitting on the board right now due to vacancies is closer than it's ever been. And we have had meetings where there may have been a majority of public members present as attorney members were either out or couldn't attend. So it's something that we're in agreement on.
Great, thank you. Yeah, I would say our public members have been active and engaged, probably more so than when I was on the Board of Governors, which is a good thing. Okay, so then I guess, is there anything else you want to say, Leah, Ms. Wilson, before we Dr. Cow and I march through our outline?
No, again, I have, some asks of all of you. Maybe that's more appropriate after you go through the outline. I don't know if you want me to, I'm available until noon. Happy to just listen in, answer questions, whatever approach you prefer.
Okay, well, I guess we'll just go through it then. And I think it sounds like the relationships topic is probably something we should come back at a future meeting to discuss in more depth, start to work on a plan. I'm not sure if there's anything in the current work plan that addresses that. So we may have to, well, that's obviously going to be a work in process. Is that fair to say?
Yes.
Okay. So how best to project our outline?
Mr. Chair,
David?
Is there a certain committee that would take responsibility over the issue that we're discussing? Or do we do it as a board?
I think my preference would be that we do it as a board. I mean, we'll probably put it under, well, maybe there will be different relationships that obviously fit with different subcommittees. But one of the things we want to discuss is the role of subcommittees. They are much less significant now than they were prior to our implementation of compliance with the Bagley-Keene Act. Remember, we used to meet, subcommittees would meet first before the big meeting.
Right.
And then, but once we decided that, at least for closed session items, that if a subcommittee met to discuss them, the other members of the full committee who were not on the subcommittee had to leave the room. We decided that having the subcommittee first talk about it and then having to talk about it again before the full committee was basically doubling our efforts and wasn't efficient use of our time. So subcommittees are, in my view these days, are more a way of subdividing topics. We'll get to kind of expectations of subcommittee members and later on in the outline. Okay. So again, what we wanted to do was just the structure we're going to use for the rest of this is we'll briefly go over our outline, but then staff has a presentation that talks about where we've been and also proposed work plans for the new year, and we'll have them present that, and then we'll come back to the outline. The idea being that staff's presentation, while it doesn't really focus on the big picture issues that Dr. Cow and I were trying to focus on, it does provide a context, and it would be useful to hear that before we then really roll up our sleeves and get into the bigger issues. And frankly, there are some small ones too, but we just want to, rather than just dictate some items, for instance, about the way our agendas are organized, I thought it was better to talk to the whole group about it and see if we all agree. The idea being my role is not to be a dictator and impose my will upon the committee, but I'm a facilitator. I see myself more as that. And so one of the first things I want to facilitate is a discussion about how we should do things and how we may want them to change, or in some cases we have to change them because the rules have changed. So with that, the outline is organized. It asks some big questions beginning. We created 4 categories: policymaking, regulatory aspects, oversight, and outreach aspects. And wanted to understand what our roles are, in that case, what the staff and the Board of Trustees understands our role to be, and ask ourselves, are there other things we should be doing? Or maybe some things we shouldn't be doing on a kind of big picture level, and then maybe more on a somewhat more specific level. And then there are committee meeting practices that we want to discuss. Those are more micro. And then we want to talk about the roles of the chair and the vice chair, subcommittees and their chairs and vice chairs, and then also what we expect even of our members, just the general members who are not in one of those other roles, as well as those who are representing us to other committees and commissions, such as the Blue Ribbon Commission, Provisionally Licensed Lawyer Working Group, that's in the past, but that's an example. CAPA also in the past. We have a continuing representative on the CS Bars, the Committee of State Bar Accredited and Registered Schools. What should they be doing? And then if you have some other issues, I don't pretend to have thought of everything. We'll want to talk about those at the end as well. And what our proposal is that we would then write up a summary of what we've discussed today, at least the points of consensus, and bring that back in January so that the committee could adopt it. And it's kind of as a manual, it has no official status, but it's something we could show to new members so they can get an understanding about what our expectations are, and it'll in effect say the unsaid stuff. So if you come to this meeting as a new member, you don't have to take 4 or 5 meetings to figure out how things really work. At least in some respects, you'll be able to read this and know, and also with the goal of having some consistency between chair years as new members come and go. So with that, I'll turn it over to Amy to start the staff presentation.
Thank you. I'm going to hand this over to Audrey, who will be introducing the planning session. But I do want to respond to your comment about the subcommittees. So the subcommittees were something that we wanted to dissolve essentially when we reorganized the work, as you noted, with the Bagley-Keene compliance and needing to meet as subcommittees and come back to the full committee. And now it's
Mr. Chair, I'm sorry to interrupt, Amy. I'm having a hard time hearing Amy's audio. It's cutting in and out. I'm not sure if that's the same for everyone else on the Zoom. I just wanted to bring it
to
this, IT's attention. A little bit better, sure.
Okay. So let me use Paul's. Is this helping?
Yes.
All right. So we did not entirely dissolve the subcommittees, despite wanting to do that as a result of being efficient with our meetings. Now it's really a way of how we organize the work, and you'll hear today from each of the subcommittees how that work is organized and why there was a need to keep it. So with that, I'll hand it over to Audrey.
Thank you. I think we're just pulling up the deck. Good morning, everyone. Thank you. That was a good response. And I can start while Tyler's pulling that up. Oh, here we go. Thanks, Tyler. So this is our staff slide deck for planning today. I'm going to do a little introduction. Next slide, please. So we're going to talk through these areas that are the same as the subcommittee areas. Examinations, operations and management, moral character, educational standards, which is also referred to as law school regulation, including 2 other groups, CS Bars and Law School Council. And some of the presentation today is a look back to the accomplishments from 2022, and some, as Paul alluded to, will be ideas and 23 from the staff to you. But before we get into some of the specifics, next slide, please. I wanted to sort of set the table with some overarching pending and possible work. We've already talked about this a little bit this morning. So we do have the Blue Ribbon Commission report coming out that the Committee of Bar Examiners will want to append a recommendation to. At the last Blue Ribbon Commission meeting, there was a recommendation to explore reciprocity for U.S. attorneys. So admitting those U.S. attorneys more on motion than having them have to take the bar exam. So if that is something that is taken up, then obviously there would be a rules revision process that we would need to do with the eligibility for U.S. barred attorneys into coming into practice here in California. And then
That would also include members of the military, judge advocates?
If they're licensed U.S. attorneys?
Yes.
Yes, right. And then we talked about the bar exam alternative pilot that is also possible with the provisionally licensed attorneys that are in the original program, which is the 2020 graduates. So again, just to reiterate, that would be committee work that would come back here as well if we need to look at supervised practice for that small cohort. So I just want to put those out there because we've talked about them, and it's not exactly, some of it's more, pending than having officially landed here at the Committee of Bar Examiners. But before we started, I just want to put that out there. So next slide, I will hand it over to Lisa Cummins and Christina Dole.
Good morning, everyone. I will be talking about exam development. So next slide, please. So the Subcommittee on Examinations has the functions that you see on your screen. So by delegated authority, the CBE does oversee the format, the scope, the topics, the content, and the grading process of the bar exam. However, the Supreme Court has reserved the authority to determine the cut score for the bar exam. For the first year law students exam, the FYLSX, the CBE has the same delegated authority. However, the CBE does determine the passing score, unlike for the bar exam. The Subcommittee on Examinations also considers petitions seeking waivers of the CBE's exam-related policies, procedures, and rules. And an example of that would be if someone wanted reconsideration of their bar exam score. That is one example of something that might come up to the Committee of Bar Examiners. The Subcommittee of Examinations also has primary responsibility for reviewing psychometric and bar exam reports. Also, as the CBE attorneys know, the question selection for the bar exams, 2 bar exams a year, February and July, comes up. Normally, these question selection meetings would be in closed session always, and in like April or so for the July bar exam, and in December for the February bar exam. The Subcommittee on Examinations also considers appeals of staff decisions filed by applicants with disabilities requesting testing accommodations for taking any of the exams that the Committee of Bar Exams administers. So there will be changes to this policy forthcoming with the testing accommodations rule revisions. The other thing too that is not on the slide, but I did want to mention, is that the Subcommittee of Examinations is delegated authority by the full committee to act on the full committee's behalf for things that may come up in between regular meetings. So, if there's something that comes up in between a regular meeting that has an urgency attached to it, the Subcommittee on Examinations has delegated authority to deal with those. Next slide, please. So the changes implemented in 2022 in exam development, these are things that we did accomplish, were implementation of the differential item functioning, the DIF guiding principles for exam developers. There was a working group that was comprised of Committee of Bar Examiners members and members of COAF that came up with these guiding principles. They have been distributed now for the last year or so to all of our exam developers. So they have those guiding principles with which to work and do their development. There also, we did continue to explore and identify ways in which diversity, equity, and inclusion, DEI principles can be institutionalized in bar exam development. And one of those things was the DIF guiding principles. We did accomplish the initial development of new subject matter matrices for each of the 13 bar exam subjects. The finalization of that will be on one of the things that the committee will be approving in 2023, hopefully. We also developed hybrid remote and in-person processes, procedures, and protocols for the EDGE team, the examination development and grading team, and the performance test drafting team meetings and performance test pre-tests, which ensure and maintain the necessary confidentiality and security. We also have embarked on a review of the first year law students exam multiple choice exam questions and pre-testing of new items in collaboration with law school participants. And then lastly, we developed and tested a new secure exam development collaboration website for use by the EDGE team and the PT drafting team. And the goal with this is to go paperless as much as practicable. And there have been challenges because of the enhanced security that's required for exam development with regard to getting something like this up and running. But it's very encouraging what we've been able to do so far, and we're still trying to work out some kinks, but that is something that we worked on in 2022. Next slide, please. So with exam development, some of the things that the committee can focus on are, as part of what Leo was mentioning, studying trends in licensing with other jurisdictions, other countries, and then review and approve the new CBX subject matter matrices, which we did begin to develop in 2022, but hope to review, finalize, and approve those in 2023. And then to also review the first year law students exam project, and that was what I mentioned in the last slide, the multiple choice portion of that exam. And then advise on bar exam features and modalities study. So in partnership with Access Lex, the state bar is doing some studies into different modalities and also question types and high stakes exam best practices. Next slide, please. This is Christina's.
For the testing accommodations, revisions to the rules, we hope to have those posted by the end of the day today. However,
Christina, can you speak closer to a microphone?
Sure.
Thanks.
We hope to have the proposed revisions to the testing accommodation rules posted for public comment by the end of the day today. Those will be posted for a 60-day time period. So by the end of January 2023, we hope to have all the public comments back so that we can review those and edit any of the proposed rules if needed. Those rules would then come back to the Committee of Bar Examiners the March 2023 meeting, and then followed by back to the Board of Trustees in May of 2023. And as I'm going to pass it over to Alex Lawrence to talk about some of the exam subcommittee work plan, one of the suggested trainings for the 2023 year would be not only to have an ADA expert come in to train staff on proper file review, but also come into one of the Committee of Bar Examiners meetings and do some training with the members themselves.
So I believe that's on the next slide. Yes, so as was mentioned earlier, and for as long as many of us have been on the committee, it's always been a great practice to have guest speakers come in and give us updates. So as it pertains to the examination development, as you can see on the slide, ensure that CBE recommendations are incorporated into the BRC, California's BRC final report on the future of the CBX, and then from. Okay, sure. Is that better? Okay.
Yes.
And then as pertains to examination grading, continue to evaluate the guidelines to address procedure for reconsideration requests for test center incidents and especially examination results. And then before we go to our training topics, last item, at least listed here, examination development and exam grading. Continue to work with the office to advance the mission of the State Bar, like we were talking earlier, and support the efforts for greater access to and inclusion in the legal system. And of course, seek input on strategies for identifying methods to diversify the greater exam developer pool from the CBE. Next slide, please. So, and then these are just a few of training topics that we did come up with. And again, it's an iterative process, but always looking for input and feedback from the group. Testing accommodations, presentation on substantive issues, on evaluating the TA requests, training on the testing accommodation process, and then from an examination, development, and grading standpoint, presentation from the PT drafting team on the basics of PT development, and then at least a presentation from the exam development and grading team or the EDGE team on the basics of essay question development. And then I'll pause there to see if there are any other suggestions or even if Mr. Torres wants to chime in as well. I think that's okay. Final. If there are none, that's
what I did want to emphasize is having two new members attending today, the presentation from the PT drafting team. If you get an opportunity, you really need to sit down and attend one of those. But they're very intense and you learn a lot. Thank you, Alex.
Who's next?
Who's doing this PowerPoint? Who's advancing it? Thank you. I will be up next with operations and management. And for operations and management, the responsibilities for CBE do involve overseeing and administering policies related to eligibility, special admissions, and exam administration. They also review and can revise rules and policies for the examinations, refunds, and violations of examination rules, which is our Chapter 6 violations as needed. They also are responsible for conducting administrative appeals of examination petitions upon request for applicants who receive a denial from staff. Some of the changes and initiatives that we completed in 2022 was procedural and policy. We did the review of the 5-year validity of CBX score, practical training of law students, law office study, exam administration, special admissions, and eligibility rules. We also had recruitment of proctors and exam administration that was taken over by PSI for February and July bar exams. The October first-year law students examination was administered by Prometric, utilizing a live proctoring platform and also using their Prometric test centers, so applicants could go into their test center and test there in person. And we also had the provisional license program set to sunset December 31st of this year, which of course that was discussed earlier on possible extensions to that. Under our aims, our admissions information management system, we continue to make system improvements as we go through it. And also under exam administration, we return to an in-person administration of the California bar exam. And we continue to administer the first-year law students examination in an online remote modality. And we did have a few people that could come in person if need be on the first-year side, but most of it was done online. And then just recently in September, the proctor recruitment was transferred from human resources back to operations and management, and we will be the ones taking over the recruitment for all of the proctors for the bar exams moving forward. And with that, we had our goals for 21 and 22. And I think I'm handing that over to my chair for this year, Bethany Peak.
All right. So the first one that we have, well, this is kind of ongoing that we always do, which is consider the appeals of individuals seeking waivers for the exam-related policies. In April and October, we review the reports of the administration of the bar exam. The next two are just continuing ongoing progress goals, considering proposed guidelines for the interpretation of the admissions rules, reviewing possible changes to authorize the law and law office study applicants to participate in the practical training of law students program. Let me see, in December and August, we will be reviewing the reports on the administration of the first year law student exam. That's something we do all the time. I know everybody expects that, just like with the bar exam. And our next one is deferred as of now, but we'll be completing the production of the admissions training videos. And I don't know if you guys remembered this. This was from like a while ago. We had talked about it, and then we were going to have these admissions videos developed as part of our efforts for communicating with the public. So that's deferred right now, but we will be coming back to that. And then also pending with the Board of Trustees right now is a review of the examination fees, specifically the cost differential for our attorney applicants. And then we will be continuing to evaluate potential revisions to Rule 4.17, which is our 5-year rule. And if you recall, that's the one where people need to get into the bar within 5 years of them passing and meeting all the qualifications. So that will, that's in progress, something that we began in August. I can keep going. Okay, so this is for our benefit. Please review. This is what our main goal is. We're here to increase the access to the legal system through public outreach and education and improve the access to legal advice and services. And we want to create a legal profession that reflects the diversity of our communities. And so that is really our guiding post as we go to the next slide. Well, as we evaluate, what do we as a committee want to really focus on for O&M? And I know that we all know that, you know, access to justice is really our goal, but in light of what Paul and Dr. Cow want us to do in terms of really evaluating, you know, big picture policy, Leah had alluded to the fact that we don't really have our thumb on what's happening around the country, like what are other people doing? You know, we're bringing, the proctoring is coming back to O&M from from Human Resources. And that's because they're having difficulties finding proctors, which I get. Being a proctor sounds like a lame job, so I get why they have a lot of problems finding them. But what are other states doing about that? Because I'm sure everybody has issues with proctors. So these are the things that we really want the community to be thinking about and ruminating on as we're evaluating our goals every meeting. Keep going? Okay. All right. So if we go to the next slide. So our work plan for 2023. Effectiveness, revising rules to eliminate unnecessary hurdles for all special admissions programs. This was, we talked about this a little bit with the, David had just asked about whether military people were, what was it we were just discussing? Okay, military spouses.
Also the assistant U.S. attorneys, assistant U.S. attorneys are getting into the bar by perhaps a board review, and also to consider judge advocates who serve in all armed forces.
Okay, so, you know, Tammy had mentioned there'll be a lot of rules revisions coming up over the next year. And so these are some of the, just keep your eye out because these are the things that we will be reviewing. Policy and systems changes. First, we're going to be taking a look at continuing our review of the admissions rules regarding, eligibility, exam administration, et cetera. Making sure that we're circulating for public comment some of those proposed changes. And then obviously after public comment, that's our opportunity to review them and for our chance to be able to provide commentary and feedback back to the Board of Trustees, preferably before decisions are made. And then obviously the policies get implemented and approved by the Supreme Court. Two other things we'll be doing this upcoming year are reviewing all our examination fees. And then, as usual, our main function for the applicants, which is considering the appeals of waivers for different exam-related policies and procedures and rules. So O&M is obviously super busy because it's it's actually administrating the bar, but I just want to reinforce and remind you all that as committee members, if there are particular areas of concern or things that, you think that we're not addressing, or maybe, you read a random article about something that, I don't know, I was going to say Wisconsin, but they're not a big state. New York is doing with, their administration of the bar, and you're like, hey, what's going on with this? Are we doing that? You should email us. Let us know. That's what Tammy is here for that. Not me. No, I'm just joking. All right, that's all I got.
Thank you, Bethany. And unless there's any other questions or comments, that's all we have for operations and management today. Thank you.
Okay, so good morning, everyone. Again, I'm Tara Clark, and I'm the program manager for moral character, and our subcommittee chair, Dolores, will be presenting with me. Can you hear me okay? Okay. And so the committee's function,
Right to the microphone.
I'm sorry? They are having trouble. Is this closer? Okay. So the committee for moral character, they oversee and administer the policies related to moral character, as well as revise the admissions rules pursuant to moral character. And I think as most of you have been a part of, conduct the administrative reviews for any applicant that requests review for a negative determination administered by staff. And next slide. And so these are some of the key changes and highlights for the moral character unit for 2022. And the two that I'll point out that the committee was deeply involved in, we had our previous subcommittee chair, Vince Reyes, and then our current subcommittee chair, Dolores Heisinger, that helped us revising the moral character application, as well as the admissions rules relevant to moral character, which, as Christina mentioned, should be out for public comment by the end of today. And I will hand it over to Dolores for our goals that we've accomplished this year. And next slide.
One of the things that's very important in moral character, one of the things that's very important in the area of moral character determination is, I believe, constant training, because it's a very complicated area. The committee members change every year, and so the need for a constant ongoing training program is very important. So the moral character goals of 2022 reflect that. We will be receiving a presentation on the dynamics of post-traumatic stress disorder on individuals. Also a presentation on state bar court cases relevant to moral character. A third area is a presentation on State Bar Ethics School and Client Trust Account School. Especially for the public members who don't ever have the pleasure of going through some of your continuing education courses that you have to take, I think it's important to know what those training programs comprise. Another thing we'll be doing will be to review and approve the revised admission rules that are currently out for public review. And then I think the key thing, the focal major thing that this committee does is to review adverse moral character determinations that have been made when the applicants appeal that denial. And so this committee meets, a couple of individuals from this committee meet to review those and make some final determinations. So that's a very, very important thing that we do. I think we'll skip the next slide, which it's similar to, same as all the others, and go on to the moral character work plan for 2023. So that the major work plan, I think, will revolve around the admissions rules. Those will come back to the committee after public comment. The committee will provide the revised rules pertinent to moral character then to the Supreme Court for approval. And if and when approved, the committee will implement the revised rules and make all necessary changes by July of 2023. Then the revised procedures to the committee will be brought to the committee for approval. So back where I started about training topics and the importance of training, we'll be looking at 3 areas of training for 2023. One is more information about lawyers' assistance. More information about the Lawyers Assistance Program. Quite often, well, I shouldn't say quite often, occasionally we will refer an applicant to the Lawyers Assistance Program for an examination, a review, and for help with those applicants' issues that they may have with alcohol. Another training topic we're looking for will be rehabilitation. Another very sticky issue. What does an applicant have to do in order to deem himself or herself sufficiently rehabilitated after receiving a negative or after having infractions that bring them to a moral character interview? That's a difficult area. Another sticky wicket that comes before this committee, I think more and more often now, is issues with unauthorized practice of law. So that those are good, meaty training topics that we look forward to having in 2023.
And I'll just add, some of you may recall some of these training topics from the last few years, but since we have several new members, we decided to revisit them. But if there are any others you'd like us to add, you can contact me or Dolores, and we'll go ahead and do our best to get those on the schedule for this year.
One of the issues that we confront quite often in this section, Dolores, and you're absolutely right, are the attorneys under UPL who come in and work for international organizations such as Google. And so I'm wondering, is there a way that these organizations, or find which ones have had, which attorneys or which corporation has had more contact with the bar, perhaps enlighten them as to what the rules are, and that will somehow give them some notice that if you don't follow the rules, then expect to be struck pretty bad. I mean, what I mean by that is to expect to be, there will be consequences if you're not following the rules, and they need to understand it, because we see that too much.
If there are no other questions or comments for moral character, then I think it'll hand over to Ed Standards.
Thanks, Tara. How's the volume? Okay. If not, let me know. So I'm Natalie Leonard. I'm the Principal Program Analyst for Educational Standards here at the State Bar. The Educational Standards Chair, Don Ajane Wilcoxon, apologizes that he's not available today, so I'll be presenting in both of our stead. Next slide, please. So in California, there are many opportunities to pursue a career as a licensee. You have the standard ABA approved schools, but we also have additional classes of schools that are unique to California. California accredited schools, registered unaccredited schools, and an option to pursue law office study, which you heard about briefly through Tammy's area. So as a result, those choosing a legal education have 50 different opportunities in California, in addition to the law office study, many more than other similarly populated states. And this has been especially important here in California, just because of the geographic diversity, and historically, more ABA-approved schools were located near major metros, but we need access to justice all around the state. Next slide, please.
Oh, Natalie, before you
Sure.
go off of that one, why did you highlight those 4 other states?
Just as example of other large similarly populated states.
Thanks.
Okay, so we talked a little bit about the different types of schools. Main differences, the ABA-approved schools are under the jurisdiction of the American Bar Association through their council on the section of legal education and admissions to the bar. So any accreditation questions related to those schools will be referred to the ABA in Chicago. But the registered unaccredited schools and California accredited schools come under the jurisdiction of this committee. The unaccredited schools are limited to part-time programs. These are 4-year programs, and they may be conducted as a fixed facility classroom program, a correspondence program, or a distance learning program. So these days you might be hearing a lot about online learning. The ABA is deeply reconsidering their online rules, but here in California, an online option has been available in the unaccredited format for a long time. And since 2019, it's also been available in the accredited format too. So the CALs can teach in also correspondence, online, or fixed facility, but the CALs can also teach a 3-year full-time program. Not all of the accredited schools have a full-time program, but some do. Next slide. As far as educational standards and the work of this committee, you'll be doing a number of things throughout the year: accrediting and registering qualifying law schools, monitoring the schools for continuing compliance, evaluating major change requests against a specified list of criteria, and then also fostering active law school engagement through our standard committee on state bar accredited and registered schools and law school council, our law school meetings that we have annually, a state bar day focused on law students, and a quarterly e-newsletter. But we're always thinking about new ways to engage, and the best way to engage. And coming out of the pandemic times, is the way that we need to communicate with schools and students going to be different? Next slide. CS BARS is composed of 7 members. There are 3 members who are deans of accredited law schools, 2 members who are deans of registered unaccredited law schools, and 2 appointments from the CBE. At this point, you've made your first appointment this year through Paul Kramer and Michael Cow, your chair and vice chair, and that is your educational standards chair, Professor Wilcoxon, who attended his first CS BARS meeting on Wednesday. These CS BAR meetings are also public meetings like this. They are held via Zoom, and the webcasts are also stored on our website along with the committee meetings as well. So you're welcome to attend in the audience. You're also welcome to look at the webcasts as well. And when there's feedback here, we usually will bring someone from the committee to address you directly. And in fact, you'll be hearing from the chair of CS BARS in a little while about the discussion they had this week related to the planning session. They do a number of things. They suggest topics appropriate for ad hoc working groups, people who may be appropriate to be appointed to those working groups based on their expertise. And they've also been very helpful, especially through these last couple of years, thinking about how to engage the law schools. Next slide. The Law School Council is a similar type of body. This one is composed of 7 administrators from ABA schools. So CS bars focused on accredited and registered. Law School Council focused on ABA-approved schools. They have some of the similar functions. The chair of that program this year is Nadia Dueñez from Southwestern School of Law, and they will focus on similar topics, but usually meet twice per year. Next slide. In terms of law school engagement, I would encourage you to start thinking about this now. We have annual meetings for all California law schools. They are the registrar's meeting and the law school assembly. Let's go forward one slide. Actually, we'll hold there. And we focus on topics of interest to the schools in general and the type of feedback you may need to continue your work. This year, based on some of the suggestions from this group and the CS BAR's work, we did a deep dive on the actual data that we have in the area of diversity, equity, and inclusion, primarily to help accredited schools to start to create their plans that are going to be part of the new rule set that they have been working on over the last 2 years. But we can think about different topics for the future, and with more notice, we have more opportunity. The registrar's meeting is largely focused on our AIMS portal, record keeping requirements for students, making it easy for the students to comply with state bar rules. We worked on a number of things in terms of overall initiatives for Ed Standards in 2022. We implemented a new software to increase interactivity in the law school e-newsletter. So now we can very easily incorporate polls or other type of feedback, make the newsletter hopefully a little bit more fun, and also give a better voice to those who are reading the newsletter. And it also allowed us to have a wider audience of law school administrators for that newsletter. Also expanded the demographic data that we collect from the law schools. This is part of a structured process that has been going on for 3 years. This is year 3. This year we added veteran status. We added self-identified disability status as well. We talked a little bit about the diversity efforts, and we also had a partnership with the National LGBTQ Bar Association. Their conference came here last summer to Los Angeles. That brought over 190 employers who wanted to speak to law students in California, and we were able to help schools connect with that opportunity. Next slide. In terms of goals for last year, there are certain goals that are evergreen in the area of educational standards, and you can see some of those here. Each year, you will be evaluating petitions for registration and accreditation and major changes in the school set, bringing new schools into the fold and managing those that are already here, monitoring compliance through inspections and reporting, and addressing potential non-compliance. And we hope that all of you will make time to participate in either a remote or an in-person inspection. And many of you already have, and thank you for investing that time to date. David?
Do you have the schools that you are intending to review already set up this year, for this coming year?
I don't have the specific dates set up, but after this meeting, I'd be happy to send out a calendar for 2023. Absolutely. Yes, this committee also helped with emergency response in light of the pandemic, how schools could operate, make changes very quickly, and determine when to return back to prior state or whether they would be returning to a new state after the pandemic. Also gave thought to continuing to pursue mandatory accreditation for unaccredited law schools. That remains an open issue without a specific timeline, but it was something that was considered this year. Deferred to next year is going to be an opportunity to meet again with an institutional accreditor. You did that in 2019, and it is probably time to revisit that in this year as you start to move ahead with the jointly accredited program. And let's go to the next slide.
Let me ask you a question there. Sure. The mandatory accreditation item, that's been on the goals list for, I think, as long as I've been on the committee. And, yet it's always, it's put off to the future. I'm wondering if, and I'm asking the group, if there's any interest in having a focused discussion about whether that should still be a goal. Because I anticipate that forcing all the unaccredited schools to achieve accredited status or basically close would close a lot of law schools. And I'm sure that's a result that many people would not be in favor of. So is there interest in us having a focused discussion about that at a future meeting?
I think there would be. And again, when we're talking about closure, we're talking about people who are non-traditional students in these schools that need to have access to law school. And again, that goes back to the access to justice issue that we were talking about with gutting.
Yeah, because the NPR would kill a lot of them, just that requirement. Okay, so we'll put it on the list to bring back sometime this year.
Okay.
Go ahead, Natalie.
Okay, so you've heard a lot about strategic goal 2 today. It pertains to most of the work of the various areas of the committee, including educational standards, about increasing access to the legal system through public outreach and education, improved access to legal advice and services, and a legal profession that reflects the diversity of California's communities, much to your point, David. Okay, next slide. So thinking about 2023, we are wanting to propose to talk about a number of things. First of all, of course, ensuring law school compliance overall for the accredited and unaccredited schools. Now that we've implemented the revised accredited rules starting January 1 for a 2-year implementation, looking to the unaccredited rules, taking the learnings that we've garnered in that process and seeing how the unaccredited rules might also be modified. Continuing to promote law school engagement, and then also reviewing and approving here in the committee the law school retention analysis that we've been working on for a couple of years. You know that we've been collecting the data for a while. Because these schools are non-traditional schools, they also have non-traditional schedules, and it makes working with the data very challenging. So it's very important that when we bring the data to you, we be able to show you not only the numbers, but the nuance behind them in terms of the schedule and flexibility that they offer to help you better use that data. So you'll be seeing that this year. Next slide. There's also an additional goal that applies in this area, strategic goal 4, protect the public by engaging partners. And let's go to the next slide. Historically, we think of those partners as our schools and our students. You may think that there are others as we think about educational policy, and that leads us to our training topics. Right now, we are proposing to bring to you training topics in a couple of areas. Getting back to a referral from Larry Kaplan earlier this year, looking at non-JD programs. So these programs do not qualify people to take the California bar exam or any other bar exam, but they are master's level programs that help largely policy analysts, those in law enforcement and other areas, to enhance their career. There have been many new programs, not only in the accredited and registered, but also the ABA schools in these areas, and the committee asked for an update on that trend. In addition, talking to at least one, maybe more, institutional accreditors. So this body is a programmatic accreditor. You accredit JD programs in law schools. An institutional accreditor looks at the structure of a school as a whole. You may have some of your schools, and most of the accredited schools are also associated with an institutional accreditor. Can learn more about how they do their work. And then also just thinking about updated trends in legal education. You might have seen just recently the ABA Journal posted an article about online education. How is it going? How is it affecting legal education? What people think about it, and how students are performing on the bar exam. That could be an example of the type of topic you would want to hear about, and we're interested in your ideas. And then before we conclude, I wonder if I could ask Devin to recognize our chair of the CS Bars for this year. This is Linda Keller, who is the Dean of Thomas Jefferson School of Law in San Diego. She just chaired her first meeting this past Wednesday, but she has already been a member. And we'd like to have her join us to summarize CS Bar's discussion from Wednesday, in which they discussed what they hope the committee will be thinking about this year and what the committee may refer to CS Bars. Welcome, Chair Keller.
Thank you so much. I'm happy to provide this brief report from CS Bars today. CS Bars was asked to provide some high-level preliminary feedback regarding project referrals from the CBE. In particular, Ms. Leonard highlighted the following topics: metrics to assess law school performance, rules, including, as she mentioned, transition to the new rules for the California accredited law schools, and potential rules or guidelines revisions for the unaccredited registered law schools. And then third topic about engagement with law schools and law students. Given time constraints, most of the CS Bar's discussion focused on the first topic related to metrics. First, we looked at the big picture in terms of when we're talking about metrics, metrics for what exactly? What's the purpose of the metrics? What exactly are we trying to measure? What is the context, and how does that fit with the mission, whether the mission of the law school, for example, or the mission of the state bar itself? And finally, we raised the questions about how we would think about using metrics for evaluation and how that might work. Members expressed a desire for flexibility within reasonable parameters in light of the different law school missions and types. Members also pointed out the potential for contradictory impacts when looking at the interaction between goals and metrics and potential cross purposes there. To just quickly clarify that with an example, you can think about how stricter admission standards at a school, for instance, might work at cross purposes with DEI goals. Attrition was also used as an example of the multiple and perhaps competing possible interpretations of a metric, illustrating the importance of thinking through how to measure, interpret, and display information in the most useful, accurate, and fair way. CS Bars looks forward to further discussions, whether on metrics or on other topics of mutual interest, and we remain at the ready to further contribute to the conversation.
Thank you, Chair Keller. Thank you, Quacking Duck. Are there any questions or suggestions in the area of educational standards?
Do I understand we're going to go back to in-person school examinations this year? Sorry? Are we going to go back to in-person school inspections this year?
I believe that we probably will be able to do that. For the benefit of the new members, historically, the inspections have always been in person. During the pandemic times, they've been conducted remotely. We may keep some portions still in the remote fashion, but probably in the new year being able to go back to in-person as well.
I think the in-person, I had an excellent time doing that. I learned a lot, and I'd be willing to do it again. I just think it's important to understand that process because it's such a huge process of what we do as members of this board.
Please try to speak into your mics, just reminding everyone, including myself.
Okay, that brings it back to me and the discussion outline that we prepared. So let me share that. I apologize that I'm not as, no, I can't make Zoom work. There we go. I'm not as wedded to PowerPoint as the staff. In fact, I joked yesterday during a meeting that they should probably enter some of themselves into the PowerPoint Olympics, if there is such a thing. But I have a Word, I'm going to use the PDF that was attached to the agenda and just kind of scroll through it to roughly align with what we're talking about at the moment. Okay, let me try to make this full screen. Not even sure where that is in Edge. Never mind. So back to the discussion of first of our broad policy roles. What we put in the memo was just some examples. I guess my first question would be, do we have the categories correct? We have 4 categories: policymaking, regulatory functions, oversight, and then outreach. Are there any other categories we should be using to align our understanding of what we do and should be doing? Okay, hearing nothing. What is here underneath each of the categories are just examples. It's not meant to be a complete list. But for instance, under policymaking, we recommend amendments and new rules regarding all the admissions functions. We also have guidelines for, especially in the case of educational standards for the new members. So we both have rules which you might equate to the corollary would be the California Code of Regulations. But then we also have guidelines that help us and interpret for the regulated community what some of those rules mean. And the difference there is that guidelines are just adopted by this committee. They don't go to the Board of Trustees for ratification or to the Supreme Court. So if we do need to make an amendment somewhere and it's an appropriate subject for the guidelines, we can make an amendment become effective much more expeditiously if we put that particular regulatory thought into the guidelines. And then we have another aspect that I think we need to keep in mind, and that's commenting on other bar programs that may affect our programs. For instance, the Board of Trustees over the last, I want to say, year and a half, was reviewing the meeting procedures and public comment policies to unify them among all the bar's entities. And Alex Lawrence and I did participate in that a little bit on your behalf. It was a case where we were asked for our input between meetings, and the input had to be provided before we could schedule it on one of our meetings. Otherwise, we would have done so. But we did that on your behalf as best we could. And we had the advantage that we had been thinking about our public comment policy ourselves. So we provided that as an example. And I think parts of it were actually incorporated into what the Board of Trustees adopted. So that was a case where our input was effective. Of course, we would prefer that we had a chance to run it by all of you first. That's our goal. Under the regulatory category, of course, we've got attorney admissions. We regulate the California registered and accredited law schools. Testing accommodations, we've recently proposed new revisions to the rules for those. Same for moral character. There's some proposed rule changes out for comment. And then we handle miscellaneous administrative appeals. We are currently handling testing accommodation appeals, but under the proposed revised rules, we would no longer do that. That would end at the staff level. And if somebody was dissatisfied with that result, they would have to take a writ to the Supreme Court. As far as I know, we are continuing to consider moral character appeals. I might ask, is there any intention to change our role in that process? We recently did change it so that we no longer participate in the actual interviews of the applicants. But are we pretty much done with changing that process as far as you know, Tara or David?
As far as I know, we don't anticipate any further changes.
Okay, thank you. Oversight function. That's kind of a new topic perhaps for some of us. It came to me, my mind, because in the proposed changes to the testing accommodation rules that would remove the committee from considering the appeals, it occurred to me that, or the question occurred, how are we going to know if staff is applying the appropriate values to those determinations, and also whether the bar is making those determinations consistently. It seems to me at least that as a representative of the three stakeholders, the Supreme Court, the legislature, and the governor, we're here to be sort of an outside check, if you will, or at least reviewer or overseer, to use the term I'm using here, of the bar's activities, the eyes and ears of those entities that appointed us. And so once we are no longer participating in the review of the appeals of testing accommodations, we have no idea what's going on. Now, I'll admit, just seeing the cases that are appealed is an incomplete view of the process, but you know, it is better than not seeing it at all. And so the thought here is, well, first of all, let me ask, does anybody believe that we should not be exercising an oversight role in the way I've described it or in some other way?
I'd like to know what evidence was there that there was a need for a change?
You mean to remove the appeals from the committee?
Right.
Well, we did go over
internal evidence, not outside.
Well, in a way that decision's already been made because we recommended the rules for the board. Now it's to put out for public comment. Now it is going to come back to us, but I guess from my standpoint, we decided that, and we heard from staff. But I'm happy to ask them to answer your question again if you want. They made an argument that it would serve the goal of providing more consistent decisions if staff was making them all internally, because they can train more easily train the people who are making the decisions. They can review them for consistency, and the implication was that because we all are a little bit different, we have different perspectives as committee members, that it would be more difficult to ensure consistency in decisions that we're participating in. Now, I personally did not find that to be a particularly compelling argument, because we could be trained just as easily. But what was compelling for me was that the process of including us in the review of those cases adds a significant amount of time to the rendering of a final decision to the applicants, and taking us out of that loop would mean that they could get their decisions more quickly. And I thought that was that's certainly a legitimate argument, and I was influenced by that to vote in favor of it.
So can I add a couple of things, Paul? to Dr. Bolton's question. I think in terms of the evidence, we weren't looking for evidence. I think this was a change that was part of an overall system improvement process, so that the idea that we would have an ADA expert in-house make some of these determinations would strengthen our process. So you've already highlighted, Paul, not only does it help with the timing of the issuing of response to TA applicants, it also helps with the professional input from an ADA expert. So those were some of the factors that contributed to that change.
And that does raise a more general philosophical issue, which is about our role. Are we supposed to be doing the nuts and bolts work of processing individual applications, or are we supposed to be making policy decisions and reviewing rules that apply across the board to all applicants? I personally am more interested in making policy and overseeing. We do, if you believe that we have an oversight role, then we do have to look at the staff decisions over time, but I don't think that has to be as they are made. It can be like periodically we go in and we look at a sampling of files and see if there's a trend that we spot that's that is suggesting that we're not being consistent, for instance, or we're not properly applying the Americans with Disabilities Act and the other accessibility laws. And then we, at a higher level, we talk about how to fix that. But we're not involved in the day-to-day decision-making on each of those individual cases. Oh, Leah, did you want to say something?
Yeah, I just, I agree with your perspective, Paul. And one of the things I was going to say earlier is that I think the policy-making enumerated list is too short, because actually all of these areas, law school accreditation, testing accommodations, moral character determination, they all have a policy overlay and a policy frame. And I think this is the area that I would really like to see CBE begin to focus. When I say this is the area, the underlying policy issues that are implicated in each of these areas, that's what I think we are really kind of missing as an organization. I just want to say that I agree with you, and I do think that there are policy issues throughout. And then on the oversight piece, my recollection is in the proposal that went forward to the board, there was an explicit mention of the CBE's role in overseeing the new TA rules and processes. So I think that's certainly something from my perspective and what we shared with the board, we anticipate CBE doing.
Okay, thank you. You understand that this list is, there's a parenthetical caution right above the start of it that it's not a complete list.
Right, yeah.
Yeah. Do you think it would be productive for us to try to create a complete list? On the one hand, it'll probably take a bit of time. On the other hand, I suppose, though, it does allow us to see the breadth of our responsibilities.
Yeah, I think it might be a good exercise and then to prioritize. The other comment I wanted to make is in response to something that came up earlier about this issue of reciprocity. I think there's another area of exploration for this committee, which is, are you proactive or are you reactive? So I think that conversation was framed as, if the Blue Ribbon Commission, adopts this recommendation, another way to look at it is, should we take on this question of reciprocity, period, end stop, regardless of what the BRC does? Because it's interesting. I mean, a lot of the work that staff has done to staff the BRC has generated really interesting information for us about what other states do, what an outlier we are, the question could be called as to whether or not our approach continues to make sense, regardless of what the BRC does. That's a big policy issue. Another thing that's come up recently to my attention is our MPRE passing score is, the highest. There's only one other state with a score as high as ours. I don't know why that is. I don't know when the last time is the committee looked at it. So I think creating an enumerated list of like, these are all the policy issues we can think of, and then prioritizing might be a really valuable exercise, as well as this question of, are we responding to, or are we proactively identifying areas that we want to generate policy recommendations regarding?
Who would we work with to develop that?
Staff, your wonderful staff that are all around the table there.
And I'm sure you give them feedback, yeah. Because they'll be focusing on, or more likely to focus on work they already do than maybe some big picture items that are coming from you. But, okay, it sounds like maybe what we can do is work on a list to bring back in January with the expectation that it will, at that point, still be incomplete, but better than this. And Dolores wanted to say something?
Yes, back on the testing accommodations issue. One recommendation, and I've got my teacher hat on today, training. Usually, the way we used to do it, we'd review the testing accommodations requests in closed session, correct?
Yes.
Okay, and that took a good bit of time sometimes. Okay. I would recommend allocating that same amount of time in closed session to a training session at each meeting that would do two things. It would be a training session, and it would also be a review of an oversight procedure. And that would involve selecting at random one testing accommodations case that's already been decided. No names, it could be totally names blocked out, to be done either by the in-house expert or staff, walking us through the whole case just the way we used to participate in the testing accommodations reviews ourselves, where we have the case, the request, what the request is, what the background is, what the psychologists, the doctors recommended, the whole thing from beginning to end, one case, walk us through it, the decisions that were made based on what circumstances. And I think that would be serve two purposes. One, over time, this committee would not lose sight of what that procedure involves. And it would satisfy our oversight requirement.
Would it though? Because you couldn't really spot trends if you just have one sample. And if one of the things you're looking for is unrecognized biases of the staff reviewers, having them walk you through it probably won't let you spot that. But I think that's a discussion for another day. When we talked about the rules the last time, we left exactly how we're going to exercise the oversight that the proposed rule described to be negotiated, if you will, at a later time. So certainly we'll discuss that approach and some other approaches when we get to that. David?
Mr. Chair, I did like one of the ideas that was mentioned by Leah Wilson with respect to examining the raw score. I know we've taken a look at it in the past, where we were just brought aware of it, perhaps during a meeting with one of the doctors that comes in to talk about test scores. But I think it's something that we should at least take a look at. And I'm not sure if it's Delaware or Arkansas that has a higher raw score than us, but I think it's an idea that we should take up, and I think it's time that we take that issue up this coming year.
Okay, I already had it on my list for a future meeting, and I'll add a +1. Okay, so, and in outreach, we've spoken, or Ms. Wilson has described a few other relationships she'd like us to work on building. Does anyone have any questions or anything else to say about that? Okay, let's roll on to the next topic, which is committee meeting
Mr. Chair.
practice.
Sorry, this is Bethany.
Oh, sorry.
Regarding the first one under outreach communications with law schools and law students, I was just wondering what you were envisioning regarding that point right now.
Well, I don't see this as new. We have the CS bars and the law school council. That's where we talk to law schools, provide them information. And you've been working on the videos for law students. We also have that, I forget the name of that program.
Law School Day.
Okay, then we have a law school day that, I guess, for students. We also have that program where we're inviting them to, it wasn't mindfulness, but it was a program to help alleviate test anxiety, I think.
Bar Exam Strategies and Stories program.
Right. But this was more a catalog of what's already going on than something new.
Okay, yeah, I just wanted to, I guess it's just a comment regarding our interaction with specifically law school, well, not the law schools, because I don't mean like CS bars, I mean students. A lot of the feedback that I receive when I tell people, other younger lawyers specifically that I'm on the committee, is that people view us as like this, like nefarious oversight like thing. And I try to tell them, I'm like, we're just a group of people that are, invested in volunteering and working for the interest of the state. But I think that feeds into a lot of the reason why a lot of people dislike us, because we are just this like thing that is doing stuff that is harming them. And so in terms of our communications with specifically like the law students, I'm just bringing this up now. I will think about it more, so I will have something more intelligent to contribute in future meetings. But to the extent that we could humanize our involvement and our role with students, I think that might help, and a very easy way to help kind of some of the, I'm gonna just use the word animosity that we receive from the legal community specifically. And I am concerned with those that are, the younger attorneys that we are interacting with more. I would love for them to feel like the Committee of Bar Examiners is an organization where if they have concerns and questions, they know where to find us, know where to reach us, and don't feel like we're just gonna, we're just trying to find ways to keep them out of becoming good attorneys. Because that is the opinion that people have expressed to me, that we are just coming up with ways to keep people from becoming attorneys in the state of California, which I know is not true. So I will think about this more so that when we have these discussions later, I can have something useful.
Okay.
And Bethany, if I can add, I think that's a great suggestion. And one idea that comes to mind is maybe having CBE members participate in our law school orientations. We're frequently asked to provide orientations to either 1Ls or 3Ls about the licensing process. And so staff present on that. And I think if CBE members wanted to join that panel, to provide either that friendly face or also to bring back information to this committee about what the current concerns that are expressed by law students, that would be very helpful too. So that might be one way to address that.
That's an excellent idea, and if staff were to put together a script so that everybody could be on board with respect to the message, I'm willing to do all the law schools, maybe 2 law schools in the Valley, but either way, I do believe that that's an excellent idea, Amy.
Alex?
Amy took the words out of my mouth too. I was really hoping, even on the BRC, I was hoping we have some kind of outreach activities at different law schools, something that we have never done in the history of this committee. And I think this is a really good opportunity to extend that offer to all the law schools.
And Tara, you also noted State Bar Day. Do you want to talk about State Bar Day?
Oh, I had just mentioned State Bar Day might be a good opportunity for the committee to participate as well, since admissions presented regarding our function, so that might be an opportunity to meet some of the students. I think last time we had, what, over 500 participants, something like that, so.
You want to explain what it is?
Oh, so I can't remember all of the groups that presented, but so it was just a general overview of several of the offices within the State Bar. So admissions, Office of Chief Trial Counsel, the Lawyers Assistance Program, and it was available to the law students. So some schools that don't have us come and present at their schools directly, I think the students go to get that opportunity to hear from us. And so this was an opportunity for those students to hear from not only admissions, but the other units within the State Bar.
Hi, yeah, as one of the more recent grads, I think that a really important first step is having someone like me within their first 3 years of practice to be here to represent those interests. And I will say that I really had to search. I had to search for what the Committee of Bar Examiners does, and that was only because I had this interest and I knew I wanted to be on this committee when I graduated and subsequently passed the bar. I think if an issue doesn't come up, a lot of my classmates didn't know what the committee did or who they were or were even really aware that they exist. So I think that also feeds some of that animosity that you were talking about, because the people that are aware of the Committee of Bar Examiners aren't always aware because of a positive interaction. And so that outreach, I think, is going to be really essential and I think really important, and also recruiting younger members to the committee that would have some of that outreach goal and insight into a newer attorney's perspective. Thank you.
After sitting here all morning, have you lost some of that distorted person that you thought we were all going to be?
I didn't have that because I did the research prior, but without that research, I might have had.
But we did take off our fangs today.
Oh, yes. Very important.
Well, I didn't get the memo. Robbie?
Yeah, and I apologize if this has come up and I missed it, but are we going back to live inducting of new members at the convention centers as we usually, well, as we did pre-COVID when people passed the bar? I thought that was a great way to introduce myself and the Committee of Bar Examiners to new bar passers. And I've had to do 6 or 7 for this most recent bar, and it's a little complicated to get it all together. So I'm kind of hoping we're going to go back to that. I don't know, Amy, if that is in our plan.
No, it's not, Robbie. So just to bring everybody up to speed, I'll be talking about the budget at a later on today. But a couple of things have factored into our decision to no longer host the swearing-in ceremonies. One of them is the fact around COVID, we explored and were able to move in, around COVID, most of these swearing-in ceremonies were canceled for the obvious reasons. But soon after that, we were able to create virtual swearing-in packets. And so that allowed people not only to get their oath packets quickly, but to get sworn in at, independent of waiting for their schools or for the State Bar to host sessions. So that it reduced the number of people that were coming to our swearing-in ceremonies altogether. So between making a lot of that material possible virtually, and also the cost savings factors in putting these admission ceremonies together, we're no longer going to be hosting them. The State Bar will not. We are providing a lot of support for those schools that want to keep them on and I mentioned we have a virtual oath packet. So we work with the schools to make sure that they are able to do, use a virtual oath packet for their ceremonies, but we are not hosting them ourselves.
Amy, what I thought that because at the swearing in ceremonies that I participated in, the Central District was also swearing in those same applicants for admission into district court. Are they not available to help with the funding? And because I'll tell you, Amy, and I know you participated in these, but I've done several for the bar where whole families come with banners and everyone is dressed up and there are pictures and people are so excited to meet the judges that have sworn them in and the committee of bar examiners, spokesperson. I had a pretty impassioned presentation that made everybody feel, proud and great. And for some reason, I thought the district court was actually the one that put it together. Was I mistaken?
Yes, no, we put those together. Some of the courts, district courts, partnered with us, but that wasn't always the case, but we hosted those events.
Oh, gosh. Well, I'm really, I don't know where that fits into the budget and all, but it's the first very positive. It's such a great introduction to the committee of bar examiners. We are the ones, after all, that certify the class for the court. And, if they only know us as the ones that administer the bar exam, it was such a positive experience. Well, I'm sorry I don't know. I know, Dr. Bolton, I think you've done one or two also. And Mr. Torres, I know you've done them too. And I found that to be, just such a great, now in Pasadena, I was doing it for hundreds of applicants and we read every name and their law school. And I'll tell you, it was pretty nice. Well, I don't want to get into the kitchen of the budget, but that was always something that I really looked forward to. But okay, thanks for letting me know, Amy. I'm crying. I know you can't see I'm crying.
Well, Robbie, let me suggest that equally important is our outreach to them before they take the bar exam. So the process of signing up early in their law education and getting all the other steps right to become an admittee is actually probably more important to them than saying thank you to us after they've passed the bar or any alternative pathway and been admitted.
Well,
Bethany, did you have something else?
I just had a question. So there's no in-person swearing in for any applicants anymore?
The schools might host those, and maybe some bar associations, but we don't host any as a state bar.
Okay. I'll just share Robbie's sadness with that. But if we're going to be doing more outreach in the law schools earlier, Robbie, you will still have your opportunity and maybe we can make an impact then.
It's just, not to be a baby about it, but, until you are admitted, this is the whole thing about the 5-year rule. This is the thing that we've been talking about for the last 3 or 4 meetings that Donna has helped shepherd through. It's being admitted. And, even if you pass the bar, or I should say after you pass the bar, you still cannot practice law until this happens. So it is a big deal. I mean, it is not nothing, and it is the beginning of your legal career. It's after that ceremony is completed, you actually can practice law. And, most of my friends' kids followed the advice on the website and just went to a notary. So they went to someone who it just is providing notary services for anyone who needs something notarized. Now, we, Committee of Bar Examiner member, I'm not sure if I was able to do it because I'm a judge or because I'm on the CBE, but I was also able to do it. And the ceremonies that I participated in were in people's homes where they invited their whole family and set chairs up. And, I wore my robe. I mean, I did my best, but it was much appreciated. Again, I know Leah's here. If you could revisit this for the future, now that we're not COVID dependent in our policy making, gosh, I just think it's, they get all kinds of packets and groups set up booths in the back for different bar association committees and young lawyers and the newspaper. It was actually quite a thing that I was so honored to participate in as one of the speakers. Gee, okay, I won't go on.
If I can ask one question about this, Robbie, this may cover what you're talking about. If I get a call from Justice Hill in Fresno with the 5th District and ask why we're not doing it, and I tell them, but invites us anyways, the script that we used to read, that the Supreme Court has gone through there or knows what they've done, and they're going to go ahead and admit them to the bar. So we basically read that script. Would we be allowed to do so as members of this committee, despite the fact that it's no longer on our agenda?
All right, so we have a few months before the next exam results are released. So we should probably, I'll explore that before our next meeting or before that happens, just to address your question.
Thank you.
Did that answer your question, Larry? No. Mike?
No, I want to offer a contrarian view. I think that you're making the right choice in terms of looking at the budget. I did one of those swearing-ins. They're lovely, but the reality is that there are budgetary constraints, and it might be better to spend the money on substantive outreach to law students or recent bar members rather than hold these ceremonies. And I think we need to think about, during lunch, come up and ask me about the following analogy: video conferencing and the pandemic, and World War I and the wristwatch. And I'd be happy to give you my spiel on how adversity creates change that in the long run is positive.
I really hate to deprive the world of that, but I think we do need to move on.
If I could just jump in, Paul, I'm going to have to sign off now, and I wanted to say thank you for including me. Happy to come back at any time, and just look forward to where your planning ultimately lands.
Okay, thank you. I think we've given each other homework, so I'm sure we'll be talking again.
All right, thank you.
Okay, so the next item on the outline was, it was under the topic of, let me scroll up here, meeting practices. And we have new public comment policy we've alluded to, and also the change from Roberts to Rosenberg's rules of order. We're going to hear about those from staff in a little later on in the agenda. So I propose that we just take these two questions and any others you may have and discuss them at that point. The next one is really open-ended, but how do we increase, if there is a need to, so that's one question, is do we need to increase committee member engagement? And if so, how will we do that? We sometimes have at the last meeting, we had a fall off in attendance towards the end, to the point where we were, every time somebody stood up, we were worried we were going to lose our quorum. And how do we deal with that? I have a suggestion in the next, a specific suggestion there in the next item, But is anybody feeling there are forces that are mitigating against their full engagement in the work of this committee? If so, we'd like to identify them and address them.
Paul,
Alex?
when you say
Mr. Chair, not-
participation, are you talking about physical attendance or active engagement in or out of the meetings?
Well, being in the meetings and both. I should let you know that I got this whiff of, and I don't know if it's in the policy, but there was talk when the Board of Trustees was looking at these other policies about a requirement that everybody's leave their Zoom cameras on, for instance. I guess the thought being that maybe people were, checking out in the middle of a meeting. And I don't know if that's come to fruition or not, but the fact that somebody was discussing that suggests that there is a concern about whether or not people are fully engaged. I was vice chair last year, so you and I, Alex, we did sometimes wonder about that and what we could do about it to make people, be more responsive as far as preparing for meetings and that sort of thing. So I want to throw it out for discussion. I don't know that there's anything particular that we need to do, but this is a let our hair down and talk everything out day, and so that's one of the topics.
So Paul, you asked, so I had a lot of trouble with my hotel room. Devin was great. I mean, she was wonderful. I really appreciated her, but figuring out what hotel to stay at and arguing with them with the price and such was a real pain. And I kind of felt abandoned when we were told we had to get our hotels and we had to go within a certain price range. And I'd like that dealt with.
And do you know?
In terms of the price range, yes, we do have to stick to something around what the state rate is. What we could do is try to get more in advance everyone who's going to come to the meeting in person and book the rooms for everyone.
We may have to ask Amy, but I think because these two meetings being in person was a kind of a, relatively speaking, in bar terms, last minute decision that they didn't contract for rooms. But I'm hoping that they're going to contract for rooms for next June and December because we know about them.
We'll just need to know who's coming in person, and then we can make the block for the whole committee in advance.
Okay, so that may alleviate that concern.
Yeah.
I think there's kind of an altering view, but Fridays are difficult, I think, as a new attorney trying to take off multiple Fridays. But then again, for me at least, my job is pretty flexible, but I don't know for how long it will be flexible. And taking off multiple Fridays, even for a Zoom meeting to, maintain maximal engagement in the actual meeting is kind of difficult. For now, I think it's fine.
Yeah, I think that's kind of a balance between.
Yeah. Not taking up everyone's Saturday.
Right,
Sundays.
well, and staff especially. As you can see, we have a lot of staff members involved in our meetings. And then there'll be an equal number of people that don't want to give up all their Saturdays as well.
Exactly.
Yeah. Robbie?
Well, Paul, I was just going to say, for what it's worth, I'm on two other boards. Both mandate that your cameras be on during the meeting, so I am used to that. And on both of those other boards, if you miss 3 consecutive meetings, you're off. You're off the board. And I don't think we enforce anything like that on the Committee of Bar Examiners, but that might be something to think about. I mean, one would hope that, I don't want to throw stones because I had to appear remotely today, but I'm here, and I think everybody that calls in is prepared. I think this is part of the gig. If you want to volunteer for the state bar, the commitment is known. I'm looking right at the description of the meetings and what we need to do. So I'd like to think everybody here, certainly everyone that I know, is super engaged, and we're all on subcommittees and doing things. So I don't have a problem with that, but I think you've got to be able to attend the meetings. And if you don't, gosh, that's what we get the most value out of, the interaction among members at these meetings.
Yeah, Bethany?
Yeah, I was just gonna make a comment, like previously, I don't think we've ever really had issues with like quorum and engagement, especially like pre-COVID. And I know that, these are very in-depth and super long meetings. And so, I get sick of sitting on Zoom for 3 hours or 4 hours or 5 hours in my living room, like on these meetings. And so I think in terms, I'm sorry, I'll just say it because it's true. But I think that, it specifically over that time frame, I understand that, engagement might have been low because it's difficult and this work does require a lot. And I think personally, I know from my point of view, I really enjoy having these in-person meetings. The work that we do, I think necessitates in-person communication. It's easier to be able to talk to the staff and ask them your questions. And I know that helps me keep engaged compared to whereas, when we're on Zoom and I have a question, I'm writing it on a Post-it note, and then I lose the Post-it note, and then 3 weeks later, I haven't asked Tammy or Natalie or whoever. And so I just wanted to make a note that I think that us returning to the in-person meetings will significantly improve the engagement for the people that have that concern about us. And I'll just say, I'm anti a have your camera on rule when we're abroad, when we're not in here, but that's just a personal preference. If it's a rule, I'll do it, but know that I'm disgruntled.
Okay, but we won't be able to see it in your face. Okay, anything else on that one? So one idea to make things a little easier is the next item, C there, to modify our agendas. So we put action items kind of at the beginning. Let me ask, we have, what about 6 people in the audience. Can I presume that all of you are here? No, is that Dean Park in the back? Okay, you're probably not here about People's College of Law, but are the rest of you here about People's College? Okay, so they've had to sit all morning. And I presume that when we finish with your item, you'll probably leave and go on to do other things. So for the convenience of people like them, for instance, would it be better to move their items to the beginning of the agenda? And then we can have our reports, about what's been going on after we conclude all of that kind of business where we have people, whose time we are occupying, watching us receive those reports later. And I haven't asked our lawyers, but I suppose that if people had to leave at the end of the day, because none of the reports require any particular action items, those of us who remain could probably sit here and hear those reports. We couldn't take any official action, but we record the meetings, and so members who had to leave early could go back and look at the Zoom recording if they wanted to receive that information. So does that idea make sense to people? Anybody have a problem with it? Okay. I will record that in the book of consensuses.
May I ask a question about that? I was on a committee that, after a while, some people had to, we're all lawyers or judges and have to leave and go to court. Some do, some don't. But once we start the meeting because we have a quorum. And then as the members, continue to leave the meeting because they have to attend a court in the afternoon, we may go under the quorum, but we're still allowed to continue with the meeting and to even vote.
Carolina or Jean, does that work?
So you need the quorum to start the meeting, and that's not just so a majority of the members meeting, of course, is a meeting subject to Bagley-Keene, so all the applicable notice and everything applies. And then you need the quorum to start the meeting because it's a motion basically to start the meeting. So you need, a full quorum to pass that motion. And then anytime you're taking a motion after that, you need a quorum of members present to take the motion. And then, it's whether or not a majority of those voting and present votes aye that determines whether it passes. So yeah, I think it's not necessarily a problem if people drop off towards the end with discussion items. Although I think it's important, like for the public, for the engagement reasons that you were just talking about, Paul, that people do commit to, participating in all of the items, not just the action items.
Yeah, well, I guess I want to balance the need to do the business we have to do, because the law school shouldn't have to wait for approval of, for instance, a change of ownership or something, just because too many of us had to leave. They should get, they should be able to get an answer on the day that their item is agendized. But if we are, as we sometimes seem to have been in the past, rushing through other items because we want to make sure we don't lose our quorum, and then we can't have a full discussion of those other items among those who are able to stay, I think that's a detriment as well. So I'm trying to balance those two. But Caroline, did you say that as long as we have a quorum to start the meeting, we do not have to worry about maintaining a quorum throughout the meeting, at
No,
least
so
when we're going to take action?
No, and so we're all going to have to adjust from Roberts over to Rosenberg's rules of order. So, be patient with us as we get up to speed on it too. But in order for business to be legally transacted during a meeting under Rosenberg's rules of order, you need to have a quorum present. And business transacted, of course, the most important business that the committee does is take action and make motions, but that could potentially also include discussions. So just a pure staff report is kind of different, but if you're going to be having discussions about topics that are under the jurisdiction of the committee, there should be a quorum present.
Okay, all right. Well, maybe then we can't achieve everything with my suggestion. Alex, Lawrence?
Yeah, I don't want to make this like a too long of a discussion on this question, but do we know why the structure is what it is today? It makes sense, but I just, was that ever, discussed or attempted before, especially before my time, like having, some of the changes that you are suggesting or we're talking about?
I think it's probably habit. That explains a lot at the bar in my mind, but.
Well, it's the old model that we had where the subcommittees would meet independent of non-members, so that only subcommittee members joined that session, and we would come back together as a full committee to approve decisions made by the subcommittee, and then things would arise. So with that model, we adopted, when that model dissolved, we adopted what we have right now, which is we're hearing all of the items, even by subcommittee. So that's how that evolved.
But the fact that we have all those, like the director's report is first,
Yeah.
That's
just
always
a
been
historical fact.
Yeah.
Yeah.
And I'm not disagreeing or whatever, just curious, like as we're looking at some of these options, which a lot of them do make sense. So, the members, they don't have to sit all day waiting for their item to come up. Just kind of curious to see like, okay, if we move in that direction, all these things that were just even commented on, how many members, is there a minimum amount of number, or to your point, Paul, like, people can view the recordings for those type of discussions that don't require action later. Again, those all sound great.
Okay.
But it sounds like we need to do a little bit of more research on this in terms of even the discussion part. So we don't have to resolve it all now, but I think we have a sense of what the issue that we were trying to address.
Okay. Next, staff would like to combine all the individual subcommittee goals, as we've been seeing them in the past, into a single work plan for the committee as a whole. The topics would still be divided by subcommittee. So you'd still see the ed standards stuff together, and then operations and management and exams, et cetera. But it would be one document. And they would prefer that we not discuss it as we do in a sort of peremptory way at every meeting, but rather maybe 2 or 3 times a year. That would save a little bit of time on our agendas, when we're simply having a motion, especially since we're always likely to need a roll call, because we'll have some participants via Zoom. and we would still have that. My suggestion is that we put it on the agenda every time we meet, but with the intent of discussing it only when somebody has a question about it, or say we want to add or modify an item that's on there. So it means we have the opportunity at every meeting, because if it wasn't on the agenda, we would have to say, okay, Bethany, you have to put a pin on that. We'll have to talk about it next time when we put it back on the agenda. So it's always there as a tool for us to use to modify, but we don't have to spend any time on it when there is no reason to spend time. How does that sound?
I, for one, think that's a good idea.
Sorry?
I think that's a good idea.
Okay. I have one vote in favor, one opinion, sorry, no vote. And then the next item is a series of meeting principles, kind of like a mini constitution, but how we would like things to go. And it's, the first thought is that we should, whenever possible, learn about initiatives that are occurring in other places, such as the Board of Trustees, in time so that we can schedule a discussion of that particular topic at a committee meeting, and then formulate any response or opinion that we feel we need to send up or out to whatever. Could be something like a Blue Ribbon Commission. It could be, more likely it's going to be the Board of Trustees. But anyway, the idea being that we have time to consider those items together as a group, rather than Dr. Cow and I being asked for our opinion on your behalf. One of my frustrations in my time on this committee is quite often I really could not honestly say to somebody that I know exactly what the committee wants to do, and I would rather that you all have a opportunity to influence these external decisions, not through my, somewhat sketchy understanding of what you might want to do, but rather because you had an opportunity to speak to it yourself and formulate a message that we could send to whomever. So this is just a principle. I propose that we adopt, and then we can show it to other people. Staff will keep it in mind as much as they can. In some ways, these principles are obvious, and maybe we shouldn't have to state them, but again, it's a kind of an understanding of the group, and to occasionally speak them and make sure that we are all on the same page, I think is useful, and that's why we're doing this. Any comments about this one?
Yeah, Paul, I think this is a great idea, seeing it in writing. We probably do this already, but it's good to see it in writing and then take advantage of, how we look at things going forward. So
Okay.
I applaud both of you.
All right, the next principle well, this is a corollary to the one above. I'm not sure we need to actually, yeah, the first two probably go together. And then the third is another variation. I apologize that I can't collapse the space between the words. The idea, and I had this discussion with Donna at the last meeting when we were putting through those regulation packets in 3 or 4 areas. The idea here is that we should have time to think about some of these major initiatives that we're being asked to recommend or approve. So we shouldn't first receive the information about the item at a particular meeting and then be asked to make a final decision at that meeting. But we should have time to first kind of present it to us, And, we'll get get our initial responses, but allow us time to think about it in between the first meeting and the second meeting, where we would take final action. For various reasons, that wasn't possible at our last meeting, but what we're trying to do here is state our preference going forward. And the other advantage of this is that it will allow time for staff to research and respond to any particular questions we might have. So we won't feel the pressure of an immediate need to adopt something overriding our desire to do it right, correctly.
Mr. Chair.
And another part of this is, if you have the information, the background information ready, don't necessarily wait until 5 days before the meeting when you normally post things, but send it out sooner. And it could be sent out via an email, so long as it's the same information that ultimately gets posted with the agenda, as far as I know. I don't think that's a problem. And the next any thoughts about that one, Larry?
I have a question. Aren't there rules about how far in advance you have to, like a report or something that's on the agenda has to go? Like, I know in government, it's like 72 hours or something. Do we have those
That
kind
may
of
be for an
rules?
emergency meeting that you call, but yeah, Bagley Keen experts, Carolyn or Jean?
No, the rule applies to when agendas need to be posted, but not when the reports need to be posted. We strive for all of our sub-entity meetings to have the reports posted at least 5 days, 5 days in advance, if not the full 10 days in advance. But there isn't a requirement on that. Obviously, as soon as we can get them done, we've talked, all of the staff have talked about, posting them on a flow basis and not just waiting until they're all complete. So we can, the committee members can get access to the materials as soon as possible. I would just also add as a caveat, Mr. Chair, to the last item. As we talked about at the last meeting, we did in fact build in for the subsequent rule proposals the opportunity, should it be needed, for you not to take a vote at the meeting that it's presented, but that you would have the opportunity to take a vote at a subsequent meeting after we've made some changes or we've had the opportunity to think. I just probably wouldn't build it in as a rule that you're never going to take a vote at the meeting at which it's presented, and just understand that what staff really need to endeavor to do is, like we have with the rest of the rule proposals, build in the opportunity that it's presented at one meeting and there's opportunity for follow-up at a subsequent meeting and vote at a subsequent meeting. And we're certainly happy to do that, especially with your caveat there, as you spelled it out, wherever feasible. That is absolutely our goal.
Yeah, these are preferences. They're not, they have no standing as rules of law. Judge Herman?
Well, that was kind of like my thought as well, that really it's a matter of there's some art to identifying in advance what the issues are so complex that they may require some additional thought. And a lot of times it's really just a case-by-case issue where it's on the materials are circulated, it's on the agenda, the matter is called, and it may be able to get a consensus on the spot. But if not, somebody can make a motion to table or a motion to reconsider at a future meeting. So
are you saying you don't think this statement is necessary or needs to be modified in some way?
Well, I think I'm agreeing with staff on the issue that you really, again, there needs to be some, there's certainly, it's certainly appropriate to have a mechanism where a complex issue that's going to potentially require some additional thought or preparation by the board that can be identified, that heads up, this matter agenda-wise might have some complexity, so that the board can be prepared in advance to know that it's an issue that's going to require potentially some additional thinking, but it really being a case-by-case issue as matters are called on the agenda as to whether they can be successfully addressed at the first meeting on the issue, or whether there is a need to push them down the road for further thought, input, et cetera.
Well, yeah, my concern is hi, I'm Paul and I'm a procrastinator, is that we not get in the habit of pushing ourselves up against the wall and then using the wall as an excuse to prevent a full and considered discussion of a complex issue.
Paul, just in retrospect, I've been on this committee for quite some time. I don't think that we've ever had that situation. Whenever there was an issue that we had to confront, we've always given it a robust discussion, and if we couldn't resolve it at that time, we would table it. I think that that's because of the flexibility of staff and our members here. I don't really think that we've ever been forced into doing something or making a decision because of time constraints. That's my recollection.
Okay, so is the consensus then that this item here is unnecessary?
Yes, and I would agree with the judge. It's like we say in the military, the situation dictates, and there is a time when a question is going to surface where there's going to be a discussion about it, and it might be a heated discussion, but at the same time, I think that reasonable minds will ultimately decide that it needs to be given additional time and perhaps resolved at a subsequent meeting.
Okay, has anybody else felt pressured to, or would have felt better if they'd had time to think about something but felt pressured to just go ahead? Kareem?
Yes, Mr. Chair. So we've had some pretty robust conversations about a lot of topics throughout the last year and since my tenure here. I will say, with the change of our format, I have seen a need to kind of not rush, but expedite decision-making in some instances. And I'm not faulting that on anyone. I just know we went from a 2-day to a 1-day. And then with the changes also with the exam, it required us to make decisions sometimes in a very haste fashion. There are some topics that we've been able to postpone, but I think for the most part, I've personally have felt that some items that a little more heated and needed more time to discussion, we just didn't have. And because of the 2-day to 1-day format, I think it just put us in that position. And I will be honest, I travel here, so leaving by 5 o'clock is really important to me, or trying our best to be out of here by a certain time, because I'm going to be sitting in a parking lot at the moment I leave. So I'm okay with staying longer if we need to discuss. I serve in another commission where we have 10 hours of public discussion on very heated topics. And so I just know with the decisions that we are in here, sometimes those things deal with people's lives, and I feel like sometimes we need more time. So I would be someone who says, yes, maybe we do need more discussion, especially with a group of 18, 19 people. Maybe that helps with engagement too.
Okay, so maybe what we do, we don't have a statement, but we understand that if we feel pressured and we need more time, that it is perfectly appropriate to call that out. Okay, and your comments relate to the next question, which was, or the next statement about we should give enough time to each item so that every member can understand a proposed action and have his or her questions answered. The question that goes along with that is, do we try to fit too much into a meeting day? And should we have more 2-day meetings as necessary? Kareem, I gather you would agree with yourself on that one.
Yeah, I mean, think about just this morning, what we've packed into the last 3 hours. That's something I think we could have done over 2 meetings, but I appreciate that we're doing it this way. And I totally would agree that I think we compact a lot. We've even had to jump to closed session to get that done and then jump back. And so sometimes I feel like we are being pushed. But that's just that's just because I serve on other commissions, and we take all the time we need. Public comment is usually the instance where I get the most conversation, and I know sometimes here we get that, and we've gotten that in the past. And so I like your style. I like that you enjoy public comment. I serve on another commission where the chair will give people 5 minutes total to speak if they wish to speak. So. No, I would never. I would never. But that's just my experience. I serve on a county commission, on this commission, and then on a regional group. And when we're discussing rulemaking and decisions, I serve on the Air Quality Management District Environmental Justice Group. Those meetings could take up to 4 or 5 hours, and they're only supposed to be an hour long. So just to give perspective.
Yeah, I can imagine those. Okay, Bethany?
I wanted to make a comment, but then I wanted to request, do you think we could have a break soon?
Yeah, actually, we do need to. If for no other reason than apparently the batteries in our microphones could expire at any moment, so they need to change those. Lunch must be here as well. Okay, I guess we should take our lunch break. People's folks, would it advantage you for us to say that we're not going to consider yours until a particular time, so you would have time to go get lunch yourselves? So if we said we'll hear you at no earlier than 2 o'clock, would that work for you folks? Okay, so yes, okay. So we're going to guarantee to the People's College of Law folks that they don't have to be back here until 2 o'clock. And we will...
Bethany, didn't you have a comment you wanted to make?
Yes.
She wanted a break, right?
Yeah, that was
the
one of
comment.
them.
No,
Yeah.
my comment was just really quickly on the bullet point we were on about the 2-day meetings. You know, I don't necessarily know that we should have a blanket rule that all the meetings should be 2-day like they were before, but I do agree with Kareem that having more time and not being so compacted on the Friday, like if there's a particular meeting where it's a whole bunch of stuff, then I think that a 2-day meeting is appropriate just so that we can have enough time to be able to fully discuss and think about and talk about the issues. So that was all I wanted to say.
Yeah, and I think it's an artifact of having more policy discussions that they do seem to expand more than a very specific action item. Okay, so should we make it a fifth? Hold on a second. Okay, so we're going to come back to continue our planning session at 1 p.m. And we are in recess until then. Thank you. take roll again, or no? Okay. All right, let's continue the discussion. Am I still sharing?
No, you need to reshare.
Okay, so we ended up, so the last item on meeting practices was regarding our preference for in-person meetings over video conference meetings, noting that the Zoom recordings of our meetings are useful, so it is good to have those. But that doesn't mean that we all have to be on Zoom. So far I've heard only preferences that we have more in-person meetings. We'll, of course, hear about the budgetary limitations in a little while on the agenda. Does anybody want to argue to the contrary? Larry, that's your job today, I guess.
Yeah, you know, I'm not going to say Zoom is better than in person, and the fact that we're doing, you know, sort of a combination. I mean, you know, I've been impressed today at the seamless integration of folks who were, you know, on Zoom, and not to mention all the.
I'm not sure they're hearing you. Your mic is pretty.
Oh. Yeah, speaking of which, right? I mean, the seamless integration of, you know, the remote stuff, not only people on Zoom, not only the video conferencing piece, but all the, you know, the the Microsoft PowerPoint and all that stuff with the folks in the room. And it's, you know, I'm impressed by that. It seems to be working really well. We've gotten better at it. The companies that make that stuff have gotten better at it. And, you know, there are definitely advantages to Zoom meetings. I mean, you know, sometimes it's a lot of times it's more convenient. It saves money. So I don't, in-person's nice, okay? And I kind of like the idea how we're doing it twice a year. But, you know, I think remote is fine. I don't have a problem with it.
Okay, well, so is the general sense of the group, though, that we prefer to meet in person? Or
Yeah. Is
okay.
San Francisco out? I mean, is San Francisco just not going to happen anymore?
It's not enabled to meet in this manner where the rooms can be integrated with Zoom, so this is the accessible meeting space.
Okay.
And they're preparing the building to sell it, so they're not spending money on those sort of improvements. Okay, so that one, I guess, stays in. Next, we talk about the roles of the chair and the vice chair. And my thought in discussing this is that, you know, it both confirms to the existing officers your expectations of them, but also lets people know who might want to apply for chair and vice chair, what the group, you know, what the job is. And we listed some of the duties here. In between meetings, as a chair, I consult, and along with Dr. Cow, we consult with staff. For instance, we went over this agenda once at a very preliminary stage, and then we had another meeting to confirm the final details. So we review the agendas before the meeting to make sure that, you know, they make sense to us, and also perhaps sometimes to remember something that we had committed to bringing back to you that perhaps staff forgot about, that sort of thing. And then with your encouragement, we'll be looking into making the agenda more friendly to, you know, to the people who would be in the audience, but for the fact I guarantee to them that they don't have to be here right now. And setting the order so that we can conduct our business and also have time to consider every item fully and fairly. And then also serving as the committee's eyes and ears between meetings, learning about things like an upcoming board initiative and thinking about preparing for it. And finally presiding over the meetings, but as I think I alluded to a while ago, I see my job as not to be dictating things, but as your guy that's assigned to look over all these details so that you don't have to, because you can't have a whole group, that can only meet in a notice public meeting deciding some things. But I want to do that with your advice and consent. I think it's fair to say that a couple of the items that we've already discussed, they reflect my agenda to a degree, but I've talked it over to you, and with one exception, you've confirmed that you agree. So that's the way I think a chair should lead, and that's what I'm proposing to memorialize a little bit here. This is a little weak on I work for you rather than you work for me, so maybe I'll add something to that in the report when we bring it back. And then the vice chair is assisting the chair with agenda reviews, as a sounding board, is kind of getting the lay of the land and getting ready, most likely to be the chair in the following year. And then this final item under the vice chair is something I tried to do this year, which is rather than just assign people randomly to subcommittees, to take into account, to the extent we can, their interests and what they would like to be involved with. What the result of that was, I ended up making one change to the committee assignments this year to honor a particular member's requests. I'm not saying it's always going to be possible, but I think it's appropriate that we check with you. Some of you may want to continue on the same committees you were on this year for next year. Others may want to spread yourself around. To the extent we can, we should honor that. And so I think what Dr. Cow is, correct me if I'm wrong, but you're thinking about talking to people when if you are appointed as a chair to finalize those subcommittee assignments. And we'd like to see that institutionalized, so that becomes what I call a habit that carries forward to subsequent officers that we haven't even identified. Any thoughts about that, concerns? Okay. Then we have subcommittees and their vice chairs and chairs. We didn't make the effort to list the topics that are germane to each subcommittee. I think you know it, and you newer folks will eventually figure that out by observation. But the reason we still have subcommittees, because with the exception of testing accommodations, they do not meet separately. And testing accommodations meets only in between our regular meetings when we need to make decisions about testing accommodations appeals. And if the new proposed rules take effect, they will no longer need to do that either. But we have subcommittees, we've always had them. They used to meet separately before the full committee met, and they would discuss the same items that were on the subcommittee. But like I said earlier, once we started applying Bagley-Keene, that meant, at least in the case of closed session items, and it may have also been the case in open session items, only the subcommittee members could be there for that subcommittee meeting, which meant the rest of the members were not there. And so if we had an item that a subcommittee would discuss, they could discuss and they could make a recommendation to the full committee. But then you might find yourselves having other members who were not in the subcommittee discussion wanting to discuss the item again to have their concerns addressed. And so it basically was a duplication of effort. And we decided, we don't need this. We'll just, we'll we'll organize the agenda according to subcommittees and their topics, but for all of those items, the full committee will discuss them. So in that sense, they're obsolete, but they do still have a role, and that's to focus the attention of members. So to the extent you don't have the bandwidth to be deeply involved in all of the topics that cut across our subcommittees, we do expect subcommittee members to be the best prepared to discuss the items that their subcommittee has on the agenda. It's not to exclude anyone else. We encourage everyone to be as fully involved as you can, but you know, you should certainly be up and thinking most, you know, to the extent that you have limited bandwidth, applying that bandwidth to your subcommittee topics. To some extent, others may be relying upon you to make recommendations, and they, to other extents, they're not. It all depends on the individual member. But that's the approach that I think. I don't think that's reflective or a change at all. I think that's just reflective of the way we've been doing things. Here's one question for the group, though. We need volunteers for things like moral character appeals and school inspections. And I think in the case of school inspections, we haven't really focused those on the members of the Educational Standards Committee. Natalie, you would probably first go to them to see if they want to volunteer, but you would be perfectly happy to have somebody who's not on the subcommittee participate in the inspection, right?
Yes, Paul, that's correct. We would encourage everyone to participate.
And for moral character, though, based on what Dolores was saying this morning, I wonder if there's not an argument that we should be more careful about just randomly bringing in somebody who hasn't been involved in moral character appeals previously. In other words, would that create the potential for less consistency in our application of our standards? That's a question for the group. Dolores, you're chairing that committee. Did you want to speak to that?
My initial reaction is that there are generally enough committee members in the moral character, and that maybe in an unusual circumstance you might reach out to another committee member who is experienced to fill a void. But I think whereas with the school inspections, I think is a separate, it's a different situation than moral character. So I could see school inspections reaching out beyond the committee, but moral character, I think only in very unusual circumstances would I recommend reaching out.
Okay, but so when you have a moral character appeal, you have two committee members are on that. So the reason I'm asking is, how would our two newest members gain that experience? Would it be by sitting on an appeal committee with an experienced member? Would that work?
I think for new committee members, the consistency of serving on a committee for a year, because we seem to be having quite a few requests, so it wouldn't be unusual to have 5 or 6 in a year, and that would give the new member, I think, some experience rather than using a new member sporadically, maybe once and then maybe not again until they get assigned to the committee. So,
okay, but we could assign one of them to the committee. And I don't have the list in front of me. Maybe we have, and then they would be. How would they gain the experience?
The committee members that are assigned are always one attorney member. So there must be one attorney member, at least one attorney member. We usually pair up one attorney member with a public member. So if you were to bring in a brand-new member for one time only in the space of 1 year, that person wouldn't, I think, would receive the benefit of a consistent training. Plus, that would leave it lopsided, because you've got one committee member, generally well, one committee member that is experienced, so.
Okay, so if somebody, we would first put them on the committee, and they would learn by osmosis by observing a little bit, and then they could participate in the appeals.
Right. So, yeah, and I think that's back to the issue of training, and I think the training sessions that we hold are very, very valuable in that regard, and would help a new member.
Paul, my experience has been where if you have 3 individuals that are going in, yes, you're all members of a certain committee, but it doesn't necessarily mean that you're going in with the same mindset. Perhaps everybody agrees that there should be some type of sentence imposed upon this individual for their wrongdoing, but that's where the independence and the knowledge of what you can or can't do comes into play. And in my past experience, I would argue back and forth with a member saying, no, I think what you're doing is perhaps too harsh. If we go this way, or perhaps if you're gonna try to keep him from the job, how do you expect him to pay off these certain bills? So I think that they need to understand the independence that they have to argue with their fellow members in that regard, in order to try to achieve a fair and just disposition in this case.
And after all, these 2 members simply bring a recommendation to the full committee.
Right.
Okay, so is it fair to say there's a preference to use subcommittee members for moral character? Less so for ed standards? Anyone disagree?
I would agree, but why can't we bring in one of the new members to just sit in a couple of them before the end of the year? Say, you're going to be on the committee next year, let's sit on 2 or 3 or 4 and just see